information, we would be able to get it. All right. So basically, we will be going through some aspects of business law. We'll be going through some aspects of business law. We can't go through all aspects of business law. Business law is very broad. So because of the nature of your course, we'll be going through some very important and key business law principles. As business students, there are some things that we should know about. I'm sure probably you've treated some of these things during your SHS and then probably some tertiary education. However, it may be long ago, so we'll just brush on it. But here we'll be technical with the law. Even though we might not be lawyers, there are certain principles that as a business student we should know. So that is what we will be going through in business law. So quickly we'll go through the course outline and then we will start with the actual lecture. If you have any questions, kindly unmute and then you would ask. But if you're unmuting, kindly make sure that your background is very quiet so that we don't get any feedback. All right. So basically, like I said, this is a one semester course. We'll be taking you through the basic principles of business law. There's the basic ones. All right, but what you see here isn't what all business law is about. There are other sections of business law. There are other sections of business law. And even, I think next semester, you would be doing company law as part or to augment the business law that you've already done. So what we have here is not exhaustive. There are other laws that are related to business. So we'll be looking at contract law, we'll be looking at commercial law, sale of goods, torts, and also the laws on agency. So part one, we'll be looking at the concept of law, what is law, and then where does law come from? And in Ghana, what do we recognize as law? Ghana here, not everybody can make a law. If I get up and I say something, it is not binding just because I do not have the authority to make a law in Ghana. So there are certain people who have the authority to make laws and certain people who do not. The Constitution has laid out the individuals who can, or the organizations who can make laws. And also, laws are such that if you do not comply with them, there are sanctions that are enforceable. That is one basic thing that distinguishes a law from just a mere statement. If I get up and I just say something, it is not a law because I am not authorized to make a law. Also, if someone does not obey what I'm saying, the person does not get punished. If any citizen does not obey what I say, the person does not get punished. So that means that what I say is just a mere statement and not law. So we'll be looking at the concept of law, the various schools of thought of law, we'll look at the classifications of law, and we'll narrow it down to the sources of law in Ghana, the people or the institutions that the Constitution has given power to make laws in Ghana. Then next, we'll be looking at the Ghanaian legal system. That the Ghanaian legal system is heavily reliant on the common law of the British, because the British colonized us. Most of our laws are based on the laws that they used. But next, moving on, you would see that there are certain customary adaptations to our laws. So our laws are heavily influenced by the British and also customary laws. So there are some laws that when you hear or you see them, you would see that basically they are from our customs. Basically, they are from our customs. So we'll be looking at how the common law evolved and how it also got here and how we also made up our own laws. However, it was reliant on the common law and also the customary laws. Now, we'll also be looking at the various court systems in Ghana. The various court systems in Ghana. Which courts can adjudicate what? There are certain courts that cannot adjudicate certain issues. So, as a business person, if you have an issue, which court should you send it to? That is basically what we are going to do under the court structure. We're going to look at what the courts, what constitutes the courts. In the court, we have the superior courts of judicature and the lower courts. So we're going through all of them, looking at their powers, looking at what they can do and what they cannot do. Now, when you go to court, it is known as litigation. If you want to settle your issues in court, it is known as litigation. However, there are other means of solving disputes. So it's not every time that when you get a dispute, you would go to court. So these other means are known as alternative dispute resolution, also known as ADR. So after we look at the court system and we look at litigation, we'll be looking at the other aspects of it, known as ADR, alternative dispute resolution. Now, these ADRs are encouraged because it has certain advantages over the court system. It has certain advantages over the court system. So we'll be looking at all of these things and see which we'll see which disputes can be sent to alternative dispute resolution and which of the disputes should be sent to court. Because there are certain disputes that you cannot sit home and then discuss. Certain disputes are there that you have to take it to court. However, when you use ADR, usually it is beneficial because the relationship or the results that come out of there is usually a win-win situation. When you sit down and you discuss your disputes, you're able to come up with creative ideas, as opposed to court that when you go to court, it is a win-lose situation. One person would win and the other party would lose. So we'll be looking at litigation versus ADR. They both have advantages and they both have disadvantages. But as businessmen and women, we are encouraged to use ADR. We are encouraged to use ADR. That doesn't mean that it is compulsory. However, in civil issues, that is in business issues, we are encouraged to use ADR. Next, we'll be going to contracts. We'll be going to contract. There are a few of these principles that I believe you've seen before. We'll be going through the laws of contract. We'll be going through the sources of law that we have in contract. And the contract or the contract that we have in Ghana is based on the Contract Act of 1960, Act 25. The Contract Act of 1960, Act 25. So that is the source of the contract law that we have in Ghana. However, we've also borrowed a few principles, or we've borrowed principles from the common law. If we see something as a common law, it's in the form of a case. So all of those cases that happened in Britain that we've adapted the principles, they are known as the common law. So our contract law is based on our Contract Act and then the common laws that we inherited. However, some of the principles contradict. And in Ghana, if a common law principle contradicts with a Ghanaian law, the Ghanaian law holds. So this is a general principle. It doesn't matter which area of law that you are in. If you are dealing with law, and there's a contradiction between the common law and the Ghanaian statute. If I say a statute, I'm talking about an act. And the Ghanaian law holds over the common law anytime. So if you are reading principles and you realize that one principle is coming from a case in the UK and there is a law in Ghana contradicting that, you go with the law in Ghana. All right, so moving on, we'll be looking at the theoretical foundations. We'll be looking at the elements of a valid contract. We'll also be looking at privity of contracts, types of contracts, rescission factors. We'll be looking at discharge. And then lastly, we'll be looking at remedies for a breach of contract. So we'll be going through all of these as part of the nature of contract. And then next, we'll be going to agency relationship. Agency relationship, the kind of relationship where one party authorizes the other party to do something on their behalf. And also, when they do it on their behalf, they are binded by that transaction. So, this is the basic definition of agency when you task someone to do something on your behalf. When you task someone to do something on your behalf. Now, we're going through what an agency is, the types of agency, how agency can be created, and also as every agreement, how an agency can be created can be the same way that the agency will end. So when something is started, definitely that thing can end. We're going through how an agency can also end. So this is basically what we'll be doing under agency. The next, we'll be going to torts. A civil law issue where you are wronged by someone. And if you are wronged, when we are going through the maxims of equity, you realize that equity will not suffer any wrong without a remedy. So we're going through the thoughts that we have. Now, with the thoughts that we have intentional thoughts and unintentional thoughts. Intentional thoughts are thoughts or are wrongs that people do on purpose. So when someone wrongs you on purpose, when someone hurts you on purpose, it is known as the intentional thoughts. So intentional thoughts can be assault, it can be battery. Once someone is beaten on purpose, that is battery. When someone assaults you, that is what also a thought. When someone defames you, someone says untrue things that tarnishes your image, that is intentional. And then we also have the unintentional one, that is negligence as part of it. Something that you didn't do on purpose, but because you should have done something else, you would have to pay a price for that. This is just a layman definition for negligence. We'll be going deeply into the both defamation and also going through thoughts. Now, as we're going through the negligence. Now, thought covers a whole lot of areas, but in this course also we'll narrow it down to just defamation and also negligence. And negligence will be looking at professional negligence and also the product liability. So these is what we'll be covering under thoughts. This is what we'll be covering under thoughts. And then last but not least, we'll be going to sale of goods, the buying and selling of items. The buying and selling of items. So sale of goods, what is the law that surrounds sale of goods? Now, sale of goods is a type of contract. Sale of goods is a type of contract. Sometimes when we hear a contract, we think a contract is only about selling and buying. However, contract covers a whole other area or what all of these areas. Even insurance is a contract. So insurance is another type of contract. However, I would not be treating insurance, but I'm letting you know that contract covers all other agreements. So if you have any agreement that is legally binding, it is a contract. And then we have the specialized forms of the contract. And one of them is the sale of goods, buying and selling of goods. So with a specialized contract, we may also have laws covering the specialized contract. So I've given an example with the sale of goods. It's a type of contract. It has its law. Insurance is also a type of contract between the insured and also the insurer. You can also have hire purchase agreement when someone buys something through hire purchase. That is where you make installments, and then after you make the final installment, the item now become yours. You have the option of exercising the last payment in order to what complete the purchase. So we have a contract for also service. We have services contract. So we have all of these types of contract coming together to form the law of contracts. Now, the general principles of contracts cut across all of these areas. However, when you specialize it, we have its own specialized laws. And one of them is the sale of goods. So we'll be narrowing down to sale of goods, and then we would end there for this business law. I don't know whether it is next year or next semester, you'll be doing company law. And the company law would be looking at both company and partnership laws and also possibly other forms of business organizations and the laws that govern them. All right, so this is what we'll be looking at throughout the semester. Yeah. We will just be looking at 6 topics throughout the semester. Now, these topics are very intensive. It is very, very detailed. So you'd have to do a little bit of reading. You'd have to do a little bit of reading. I'll be sending you some notes and you'd have to read further on these principles. All right, so let's start with the part 1 and part 2, which basically talks about what is law and also narrows it down to the legal systems in Ghana. All right, so basically, law affects every aspect of our lives. Now, sometimes you've heard people say, or I don't know whether it has happened to you, you've heard people say that you don't think there is a law governing something until you find yourself in trouble. That is where you would find the officer reciting laws that you didn't even know existed. So there are these laws that govern almost every part of our life. Realistically, the laws cannot affect all parts, or we cannot have every single law for every part of our life. But we rest assured that almost every aspect of our lives, we have laws governing it. The way we relate to people, even who we can marry, all of these things, we have laws governing them. So, as business students, we should also at least have a fair idea of what the law says. We should have a fair idea of what the law says. So, the law influences all parts of our life from the time we are born. Even before we are born, the law protects us. And also, after we are dead, we have laws that also protect us. So we have the wills where you can write your wills, and then your will would have to be respected. Your estate that you leave behind would have to be respected. Now that is even after you are dead. You are not here, but we have laws protecting you and protecting your interest even after you are dead. So the law affects every single part of our life. And although we are doing business law, we can extend and then also read on other types of law to enrich our understanding. So that anything that we do, we will know that, okay, so definitely we have an idea of whatever we are doing because every single aspect of our lives governed by laws. All right. So we have laws that govern our working conditions, employer-employee relationships. There are laws that govern our relationship with our employers. For example, we have the minimum wage. They cannot pay us below the minimum wage. At least the wage that we are being paid should be equal or higher to the minimum wage. If not that, then employers could have paid us any amount. Employers could have paid us any amount. And if we are also employers, we should know that we cannot pay anybody any amount just like that. At least it must be equal or what more than the minimum wage. Also, we have health and safety standards. There are certain jobs that it is prescribed that there are certain things that you must provide for your employers, especially if they are doing very dangerous works. There are safety caps, safety overalls that they wear. All of these are prescribed by laws. Even how we have fun is regulated by law. How we have fun, how much alcohol we can drink. After drinking the alcohol and having fun, what we can do and what we cannot do. After having fun, you cannot drive whilst you are drunk. So laws also affect even how we have fun as a society. Now, even in Ghana here, certain strands of marijuana are illegal, unlike certain parts of the US where they have this normal recreational marijuana. In Ghana here, I heard that medicinally they've made certain marijuanas at up to a certain limit legal for medicinal purposes, just for medicinal purposes. But for the US, they have a recreational one that you can just smoke and then use that one to enjoy yourself. That one, it is no. So if you think that you're just having fun in Ghana here, you cannot do that in order to what relax in Ghana. So even what we do whilst we are having fun is regulated by law. The example that we have here is where they banned alcohol on buses. If you see coaches, we are talking about buses and trains whilst you are traveling to the football matches. Because once you get there, you might be having a little bit of too much fun, and then what it may cause commotion. So because of that, we have what regulated the what intake of alcohol even when we are going to watch football matches. And also we have laws that control our personal relationship. We cannot say that we own ourselves so we can do whatever that we want. There is a law against incest. There is a law against incest where you cannot marry your own sibling up to a certain relative. So you cannot say that because you are an adult and you can do whatever you like, you would want to marry your own sibling. No. So we have laws that even affect our personal lives. So almost all aspects of our lives are governed by laws. Almost all aspects of our lives are governed by laws. And we should at least have an idea of what these laws say. Here we are in business, so whatever we are going to do, we are going to try and relate it to business. But even in other aspects of our lives, we should try and then have an understanding of the laws that surround those areas. So, what the concept of law? What is a law? What is a law? So first, we are going to start from a rule, and then we are going to broaden it to a law. So a rule is something, or a rule are statements that are to what encourage or compel certain acts if a society desires that act. So a rule is to encourage or compel certain acts if the society desires that act. So if a society desires that act, then the society can take steps in order to what, compel certain behaviors. Now, sometimes we conflict rules with laws. Now, rules usually cover a minor portion of the law. So a law can be a combination of rules. But when we look at the reach of laws and the reach of rules, rules can basically be set by any other authority. Rules can be set by any other authority. But for it to become a law, the person must be recognized in that jurisdiction. In Ghana here, our jurisdiction is the whole Ghana. In certain federal institutions, they've broken it down into states. So in the US, certain states have different laws to certain states. So you go to one state, there's a different law on something, you move to the next state, the law is also different. But in Ghana here, from the northern region, from the upper east, upper west, down to Greater Accra, covering the coastal areas, we all have the same laws. In Ghana here, we don't do the federal system. So we are all under one jurisdiction. Now, rules cover what minimum portions of what a law is. For example, even in a house, parents can set rules. Parents can set rules for their children. So they are making statements that are enforceable only in their house. So when you compare rules and laws, sometimes can be used interchangeably, but rules cover a minimum portion and then laws are what covering a whole jurisdiction. Also, rules, when it comes to laws, they are legally enforceable, but rules, usually they are not legally enforceable. Even though it can appear in court and then the court can decide, they are deciding on the fairness and not the rule itself. So rules cover a minimum portion of society, whilst laws cover what? Whole jurisdictions. So even in a class, we can make rules and regulations, no late coming, all assignments should be submitted on time. All of those are rules. But when it comes to laws, laws cover a whole jurisdiction. So when we say laws, laws are a set of rules. So they are what? A set of rules that come together that are enforceable by the courts. That are enforceable by the courts. So the example that I gave earlier, when you are a parent and you tell your child that by 9 o'clock, the light should be off and they should be asleep. Definitely, when your child doesn't sleep at 9 o'clock, you cannot sue your child because you set a rule that he should sleep at 9 o'clock. So that's what this petty things differentiate a rule from a law. So coming back to laws, laws are a combination of rules that are enforceable by the court, and they regulate the relationship between the government and the citizen and also among the citizens. So they are a set of rules enforceable by the court, which regulates the relationship between the government and the citizens and also regulates how the citizens also interact with each other. That is why even though the government is there, there are certain things that the government cannot do. If you feel like any governmental organization or any authority is going beyond their powers, you can actually sue them in court and also go to court for a remedy. So these laws regulate the relationship between the government and we the citizens. And it also regulates the relationship between the citizens. That is why we cannot get up and do whatever we want. This is not a jungle where the strongest survive. No. That's why I cannot just go up to someone and just beat the person up just because you are strong and just because you can. That cannot happen. So there are laws that govern us. Now, the laws are also a set of rules and regulations that regulates and guides behavior of individuals and the state, which comes with sanctions, and the sanctions are legally enforceable. Anytime that you are defining a law, make sure that two things are key. One, sanctions, and two, legally enforceable. Legally enforceability is talking about the court. So if a statement comes with a sanction and that sanction is legally enforceable, then that becomes a law. Without it being legally enforceable, it is just a mere statement. Without it being legally enforceable, it is a mere statement. So these are the definitions of law. They are not exhaustive. There are more definitions of law, but we just narrowed it down to these two. Now, let's look at the school of thoughts. There are a lot of school of thoughts on the definition of law and what a law should be. But we are just going to narrow it down to two fundamental principles or two fundamental school of laws. So when we say what is a law, people have defined law in various ways. But what can we say a law is? So for there, we have the positivist view and then we have the naturalist view. The positivist view and the naturalist view. Now, when you look at law, some laws are combinations of all of these definitions. But some people believe that a law should be this, and some people also believe that the law should be that. They all have their demerits and they all have their merits. But this is what they think the law should be. So these are our schools of thoughts. Now, please, if you don't have a question, you mute yourself. You only unmute when you have a question. Yeah. All right. Thank you. All right. So we look at the positivist approach. Now, the positivists view law as law that comes from someone with authority. So if a statement is coming from someone with authority, that statement becomes a law. They don't care whether it is fair or it is not fair, whether the person got the power legitimately or illegitimately. Just because a person has authority, any statement that comes from them should be regarded as law. That is what positivists view law as. Statements coming from people who have authority are laws. and should be obeyed at all costs. That is their definition of what law. So according to the positivist, if someone has authority, the person can be a king, the person can be a president, the person can even be a dictator. But whatever the person says becomes law. That is their school of thought, that anyone who has authority and they say something, that statement becomes a law, and that statement is binding. But when we go to the naturalists view law as good and bad. So they look at law from what? Nature, from the universal moral order, where they choose and pick laws based on what is good and what is what not good. So they choose law based on what is good and what is not good. And then they make laws to encourage things that they view as good and things that they view as bad. So that is the naturalist school of thought. So they believe that if a law or a statement is coming from a dictator or someone who has power, but those laws are not moral, those laws are bad, then those laws should not be regarded as a law. That is what the naturalists are saying. They are saying that even if it is coming from someone who has authority, but those laws are not morally good, then those laws should not be regarded as laws. So these are just what school of thought. And then when you look through our laws, you would find that they cut across all of most of these things. Because there are some laws that are just laws because someone in authority says they are laws. And there are some laws that when you go through them, you realize the meaning or the reasoning behind the law. And then you see that, okay, so this is the reason why we actually went for that law. Now, one drawback of the positivist view is that when they see someone who has authority making the laws, then it can also be very dangerous because some very bad people can get into position. So if we are viewing law from that perspective, then it means that even if they make bad statements becoming law, that law will be enforceable. That is one drawback from the positivist view, where even if they make some bad laws, it is still regarded as law and it is still regarded as something that should be obeyed. And then when we come to the naturalist, we tend to now look at what is morally good and what is morally bad. And sometimes these things can differ across across jurisdictions. And it can even differ across generations. Because we have certain things that in certain societies were regarded as bad, but now when you go there, they now regard it as good. So when it comes to a naturalist, what forms the moral standard? Who says something is good and who says something is bad? What is it based on? Because something can be bad yesterday, but in that same jurisdiction, as we go and we learn, we realize that we will come to adopt it as well something good. For example, this LGBTQ, when you go to the more advanced countries, it was illegal, now it is legal for them to do. So when you ask someone from there who's a liberal person, the person will tell you that he has no problem with it because he doesn't see how that hurts the society. But in Ghana here, there was an anti-LGBTQ, and then one of the arguments was that it is not compatible with our customs. So you see, even jurisdiction-wise, it is very difficult to decide what is good and what is bad. And also over time, because even in the advanced countries, previously they used to view certain things as bad. But as time went on, they now realize that, or they now see these things as good. So the naturalist law, it sometimes becomes very difficult. It becomes very difficult to pinpoint what is good and what is bad. So these are just the school of thoughts. This is what this school of thoughts think, that what a law should constitute. Positivists believe that a law should come from someone's authority, while the naturalists believe that we should be able to distinguish between what is good and what is evil. So that even if someone has authority and a person is giving us a law, if the law is evil, then that law should not be obeyed. So this is just the various school of thought concerning laws. Now, functions of laws. Functions of laws. Now, the class has been quiet, so I would want one person. So you come here and then you would pick a statement and then you would explain to us. So anyone, the class has been quiet. And when it is online like this, probably someone sets the device and then the person is sleeping somewhere. So I would want us to make the class a little more lively. So anyone to help us? Anyone to help us? Anyone to help us? Or should I mention names? You pick one. This is something that we've seen before. You pick one and then you help us explain what, or help us give a definition, or you explain what you think we mean by what's on the by what's projected. Anyone? Hello, Beatrice Bequin. Are you online? Hello, Beatrice Bequin. Are you online? Have I been speaking to myself? Prince Boache? Hello, Prince Boache. I'm not asking you for a thumbs up. I'm asking you to pick one and then explain to the whole class. Yeah, there are no wrong answers. So just pick one and then just explain to us. Like these are functions of law. These are things that we've all seen before. Things that we've all seen before. So just pick one and
So
then
I will take the
just help us
first one.
explain. All right, thank you.
I will take the first one.
All right.
Keeps the peace. When you said that laws are a set of rules that is enforceable by law, or that is enforceable by court, and if someone breaks it, the person will be penalized. So, based on the law, we are saying that in a society or in a business community, this will bring about peace. Because if a person or a business or an organization knows that whenever he goes against the laws of the state or the laws of the business community, it will be penalized. It will make sure that don't do anything that will deteriorate the peace in the community or the peace in the business community.
Okay. Thank you very much. So yes, when it comes to keeping the peace, there are certain disorderly things that people would have done if not for punishments. Some people would have done disorderly things if not for punishment. But for the sake of punishment, some people do not do certain things. So this is what we call the deterrence approach to law. If you know that or you've seen someone get punished heavily because they've done something, you are not going to do that. So if you have anything to do that is going to disturb the peace of the nation or disturb the peace of someone else, you know that definitely if you do it and you'll be punished, you are not going to do that. And it is so because of laws. If there were no laws, people would have done whatever they wanted. If there were no laws, people would have done whatever they wanted. But because there are laws, we cannot just get up and do whatever we want. So because of laws, we cannot just get up and what? Disturb the peace. And then to maintain the status quo, who can help with this? Maintain the status quo. Now, what is the status quo? We are talking about maintaining something as it is. maintaining something as it is. Now, it helps us maintain the orders that we have as a society or as a country. Now, if you want to change something, there are ways that you can change that particular thing, especially if you think that that thing is not good. So you cannot just get up and change everything just because. So the law helps us maintain the status quo in a way that it helps us, excuse me, make sure that the society is stable and organized. It prevents sudden and unnecessary changes that can cause confusion. Now, if there should be changes, the changes should be made gradually, and should be made in accordance to the laws. It avoids unnecessary changes where you can just do anything at any point that you want. And then next, it preserves individual rights. That is why there are certain things I cannot do to you, and there are certain things that you can also do to me. It preserves your rights. I cannot just come and fix you, or I cannot just do something that will put your life in danger, because you have the right to life. So it protects our individual rights and freedoms. It even extends to our property. That is why I cannot just come and enter into your house. However, when we are talking about rights and freedoms also, we should know that they may have certain limits, because as we've all heard as a general saying, your right ends where someone else's right begins. So I have a right of movement. I can move anywhere that I want. But I cannot infringe on your right to privacy by just moving into your room. Without I will be trespassing. So it helps preserve individual right. There are certain things that you cannot do to me, and there are certain things that I cannot do to you just because you have your own rights. If you know your rights, anytime that someone wants to breach them, even if the person is a law enforcement officer, you will let the law enforcer know your rights. Because if it appears in court and, for example, you tell them what exactly happened and there was a breach of rights, then the person might be caught wanted. When it comes to laws, it helps protect our individual rights. Now, next, it protects minorities against majorities. Here, generally, we are talking about people who are perceived as weaker parties. Now, for example, we have men versus women, children versus men. In the society, we view men and women and children as minorities. Now, in actual fact, women are more than men. But when it comes to power and authority, we view women and children as weaker parties. Just because of how society has evolved and how women has been discriminated against. Now, when it comes to minorities also, in Ghana here, we do not have a lot of minorities. But when we're talking about weaker parties, we could be talking about employer-employees. So anyone who has more power than you, the law protects you against that person, even landlord and tenants. So we have laws in certain relationships. You can see that there are some weaker parties and there are some stronger parties. And because of that, the law doesn't want the stronger parties to abuse the weaker parties. So there would be laws to protect the weaker parties. That is why there are more laws protecting children and women as compared to laws protecting men. When you go into the business world, you see that laws that protect employees are more, because employees are viewed as the minorities, or are viewed as the smaller or weaker parties. When we go outside Ghana into the other parts of the world where we have several people of color, so we have multiple ethnicities, we have people of different racial background, we can also extend it to that point where we have laws protecting people who are viewed as minorities. So, for example, in the US, if you're a black person, you're an African, we are viewed as a minority. So we have laws that are going to protect the minorities against the majorities, because these minorities are viewed as weaker parties, and the law must protect them against the stronger parties. Now, the law also promotes social justice. The law encourages fair and equality so that everyone gets equal opportunities and equal treatment. Now, even though some people are going to argue about this, the law is such that people, so the law is such that it is designed in a way that is going to make you get fairness if you pursue it. However, as individuals and as human beings, sometimes we have this notion about the law that it only protects the rich, and then some people are above the law and other things. But the general spirit of the law is that everyone should be treated equally, and everyone is not, or no one is above the law. Now, next, it also provides for orderly social change. Now, the law allows society to change in a peaceful and organized manner instead of through conflict and violence. This one goes ahead to reinforce the status quo. That as the law is keeping the status quo, if we find out that there are certain things that are not in line or certain things that are updated, the law has provided ways in order to what? Change those things. So even things in the constitution, if we want to amend it, we can amend it through what? Voting. So parliament votes, and then there will be a referendum, and then there will be what? An amendment in the constitution. So there are certain things that we don't just change it through violence. So the law also, whilst keeping the status quo, it also provides a way that if we really want to what? Change something, we can change it in an orderly manner and not just burning things and then what? Through violence. No. So even though the law is almost static and the law is also maintaining the status quo, it also paves way for us to what? Make changes in an orderly manner. Now we have classifications of law. Now these classifications that you see, they are being classified based on certain themes. So there are certain, I've changed the slides, but the slides are not changing. Hello, can you hear me?
Yes,
Hello, can
Yes,
you
we
hear me?
can.
Yes,
Yeah.
yes.
Yeah, and can you see the classifications of laws?
No,
No,
please.
still on the function.
only the functions of law.
Yeah, yeah, I don't know why. This one I'm coming. Is it changing now?
No, it's still the same.
All right, please, I'm coming in. So I please hope it's visible now. Hello, I hope it is visible now.
But it's still the introductory part.
It's
Business law. That's what we
Hello,
have.
okay. Okay. So we have the
but it's not
classification
moving.
now.
Now it's here.
No, it's moving.
All right, thank you very much. Thank you very much. All right. So when it comes to classifications of law, we classify based on certain themes. So the themes that we classify under, sometimes we must be very careful and make sure that we do not mix them. So when we are comparing common law and civil law, we are classifying it based on the system we have, based on the system of laws that we have, and not just any other comparison. And then when we compare common law and equity, they were both practiced in England, but how they emerged and how they are being viewed, that is how we are looking at it. And when we also compare public and private laws, we are looking at laws that govern the state and the citizens, and also laws that govern the citizens themselves. So you may see common law appearing multiple times, but the definition that we give to them is very different. Because common law being coined, common law, when you mention common law, there are laws that we inherited from the British, but common law can also mean certain things in certain instances. As we are going further, you would see that in the Constitution. The Constitution also gives a further down definition for common law. So let's pick common law and civil law as what systems. So when we are differentiating between common law and civil law, we are differentiating them based on what systems, the system by which they find themselves in. Now, the common law originated from the British. The common law originated from the British. And then the British were using the common law system, where they were basing all their laws on judicial decisions. So they go out and then they help solve disputes. Now, as they solve the disputes, the decisions that the judges will come up with, that would be what is the principle governing it, and that becomes a law. So that is how England came about with their laws. They went around, they were just helping people resolve disputes, and then as they were doing that, they started adapting the best practice and dropping the ones that were not that good. So based on the decisions that they were making on the cases, those became principles and those became the laws that governed England. However, when it comes to the civil law system was actually based on a codified structure. That means that they have their laws codified, they've written their laws. And then based on that, when your dispute comes to court, they will have to go through the codified laws and come up with a decision. So these are two systems of laws. One originated from England and one also originated from the European nations. So from the other European nations, they were using the civil law system, whilst England was using the common law system. So England, decisions made by the courts became laws. However, when it comes to the civil system, the judges did not have the privilege to do that. The laws were actually written, and then based on that, the judges were interpret the laws. Now, as Ghana was colonized by Britain, we know that we've adapted the common law system. So most of our principles is based on that. Now, even though today Ghana has written laws where we interpret, we still practice the common law system, where a judicial decision is binding on all subsequent courts. So Ghana still practice the common law system, where if a decision is made by a judge, that decision becomes a principle and it also becomes a law. But when we are distinguishing between common law system and civil law system, one is based on judicial decisions and precedents, and the other is based on codified statutes. And then one originated from England and the other originated from the other European nations. So most of the time, the Commonwealth countries, most of them have adopted the common law system. The Commonwealth countries I'm talking about countries that were under the British, the Britain rule, and other former Commonwealth countries. Most of us have adapted the common law system. I'm saying us because Ghana is part of the Commonwealth. So most of us have adopted the common law system. Now, next we go to common law and civil law. Common law and civil law. Now, this is a distinction in England itself, because as they were going around solving issues, some people were of the view that the principles that they were using was very unfair. The principles that they were using were very unfair. So they will now go to the king and then petition the king that the decisions that are being made by these judges were unfair. And that is where the king came up with the laws of equity. So the king also set up a different court of what, being the court of chancery, where they had the what, court of equity. So I think this slide should also be the equity, because the equity starts from the slides. I'll correct it. Yeah, so this is equity here. Now, even though we are distinguishing between the common law and the rules of equity, let's start from let's do a little bit of revision from where Ghana started from. Now, as we all know, Ghana's laws are rooted in the common law tradition. Now, we are going to look at how the common law evolved and how the laws of equity also came to be, and why there was a distinction between the common law and the rules of equity. Now, mind you, in Ghana, when we mention common law, we are talking about both the common law and equity being adopted. However, in England itself, there was a distinction before they decided that one court can man this whole or one court can decide on these whole issues. Now, the common law system developed in England in the Middle Ages. Now, before 1066, different parts of England were governed by different local laws introduced by various settlers. So as people were settling in England, they had different laws governing them. So before they were conquered and then they all came together as one, they were all using different laws. Now, in 1066, when William the Conqueror conquered them, judges were sent all across England to administer justice and set rules that would apply uniformly throughout the country. So they didn't want each part of the country to have different rules. So when William the Conqueror conquered them, he made sure that he sent judges. And as he sent the judges will just go around, and then they will listen to the court, the court's best practices, and based on that, they will use it to come up with a decision for them. Now, when they returned to Westminster, that is where they were. They discussed the different laws that were present around the country and decided on which one to keep and which ones to dismiss. So the judges will go out, they will help solve issues based on the principles that they already had in the other part of England. And then when they came back, they will just sit down and discuss it. Okay, so which of the rules were I've said, which of the rules were sensible, which of the rules are good to be kept. So they discuss, and then they will keep the rules that are good, and then they dismiss the ones that they thought were not that good. So even though they were going to different parts of England to apply different rules, when they come back, they will sit down and then they will discuss it. And this led to they moving towards a single principle. So the various rules developed became known as common law, and was exported around the world to many Commonwealth countries through colonization. So this one, as we all know, the common law was exported because every country that was a British colony was now being governed based on the common law principles that has been developed in England. So even though we were not part of England, if you are colonized, you are viewed as a colony, you would be or the common law will be administered in that country. Now, before the 12th century, the common law court has been established to apply the common law principles. That is because they've now what gone around and what they've decided on cases, and then they will come back and then discuss the cases. They moved towards a point where they standardized the laws, and then they came up with what similar laws to govern what, or similar principles to govern what similar issues. So as they were coming together, they said what they came together and what they made a common law, because the common law was applicable to everybody under England, or what who was in England. So what they came up with, what, that's where the common law came, because the common law became what common to be what applicable to what every part of England. And then as they colonized other countries, they also what sent their common laws there, and then what they governed the people with the common laws. Now, as they develop the common law courts, where anytime that you have an issue, you would what be issued a royal writ before you can begin a civil action. Now, each writ was applied to a specified course of action, and the litigants had to fit their circumstances into one of the available type of writs. So they have types of writs that you can use if you want to go to court. So this writ will be issued, and then what you would have to make sure that your case fits one of the writs. However, this led to what a disadvantage to other people, because sometimes there are some writs that does not cover certain parts of the dispute that you want to resolve. So this was one of the disadvantages of the common law. That is why the Court of Equity came into being in the same England. So in the same England, they were administering the common law and the what rules of equity, because of what these disadvantages to other people. Because sometimes in the common law, there's a writ, but it does not cover your dispute. So because of that, you cannot go to court and have your what and have your issue heard by the court. So we look at certain weaknesses of the common law system that led to the loss of equity. So one, if a case did not fit a type of writ, there was no way of bringing the case to the law court. To the law court. That means that if you couldn't find a way to make sure that the writ fits your case, you cannot send your case to court. And also, a party who commenced a case with the wrong writ was thrown out of court. That means that if you do not apply for the correct rates and you go to court, as the case is going on, when they find out that your rate is wrong, all the case will just be dismissed. Also, the common law did not recognize the beneficiary's right in a trust and only recognized the trustee as the legal owner of the trust property. Now, as the common laws were building, it evolved certain principles that were very unfair to certain people. So, for example, it didn't recognize the right of trustees. A trustee is someone who an item has been given to for in trust of a beneficiary. So, for example, if you are not 18 years old, you are not an adult, and then your parents are leaving for war, or maybe they are about to die and they want to leave a property. Because you cannot own property, they can give the property to someone else in trust of you. That if you become an adult, the person should just transfer the property to you. However, under the common law, they didn't view the beneficiary's right, but they just looked at it from the point of view that if the item was transferred to someone else and the person's name was on it, then the item now belongs to the person. So it was a principle that if an item belongs to you, then it means that you are the owner of the property. The item is under your name and it's what your property. It doesn't matter whether it is in trust or it is not in trust. So, for example, if a father is going to war and the children are not old enough, the father can give a land to the uncle, that is to his brother, that is to the children's uncle, that if my children become adults, transfer the land to them. However, if the children now turn 18 years or become adults and want to take the land from the uncle can just present the document that the documents are in his name and then he is the one who owns the property. So because of that, the land will not be transferred to the children who the land actually belongs to. So the common law was recognizing only the trustee's right and not the beneficiary's right. which was very unfair to the beneficiaries because the item actually does not belong to you. It belongs to our father. However, because we were not adults, our father gave it to you so that when you become adults, you give it back to us. But because of the principles going around in that time, it will only recognize the trustee's rights and then what at the expense of the beneficiary. So that was one of the weaknesses of the common law system. That is where the loss of equity started what coming up in order to what correct these wrongs. And lastly, the only available remedy was damages, monetary compensation, and it was not adequate in most cases. So if there is a case and then you go to court, the only thing that they can do is that it doesn't matter how hurt you are, it doesn't matter what the person did, just take money and then what? They believe that you have been compensated. But money cannot solve everything. Someone is unmuted. Does the person have a question? Someone is unmuted. Does the person have a question? And I cannot find the person too. All right, let's continue. Please, if you're unmuted, kindly unmute yourself. Kindly unmute yourself. Sorry, if you're unmuted, mute yourself. Sorry, if you have unmuted, mute yourself. Yeah, thank you. So the common law only gave remedies in forms of money, cash, and sometimes these monetary compensations were not enough to compensate certain people. Some people will decide that they will enter into a contract with you and then they will not perform their duties. If you go to court, the worst the court can do is that just tell them to pay money, and because they are rich, they'll just pay the money. However, when the loss of equity came, they realized that because people were doing that, they established specific performance where even if you don't want to do it, the court is going to compel you to do what you decided to do under the contract. So with the common law, it was what? Very, very rigid because you needed to find a rate in order to apply to. And if you apply to the wrong rate, your case will be thrown out of court. Also, it was kind of unfair because it didn't recognize certain aspects of life and certain complexities of life that sometimes a document or a property can be with someone, but the person is not the actual owner of it. The person may have been given the property in trust of another person. However, the common law did not actually look at that. And also, the compensation that they were just giving was just monetary compensation. So people can just go up and just do anything that they want because they know that no matter what, the compensation that they would have to pay is what? Money. They wouldn't have to do any other thing than to pay just money. So, due to these disadvantages, people started petitioning the court that the common law system was what? Not fair. So the courts now referred these people to the chancellor, which led to what? The creation for the what? Court of Chancery. So the Court of Chancery is the same as the Court of Equity. Now, the chancellor applied the principles based on what? Sources such as the Roman law and then what? The natural law. We've already done the natural law. Natural law looks at what is good and what is what? Evil, what is just and what is not. Now, rather than to apply the common law, now the chancellor did not apply a rigid rate system. So if you go to the common law and you think the decision was unfair, you can petition the court who is going to what? Direct you to the chancellor. Now the chancellor is the one who is going to what? Try and then what? Resolve the issue in a what? More fair and what? Equitable manner, rather than apply the rigid rules of the common law. So proceedings in the Court of Equity began with bills being presented by the plaintiff in a vernacular language and not in Latin. That means that they did not also what? Formalize the language in which you can what? Present your case in it. Also, the defendant was summoned by a writ of subpoena to appear for personal questioning by the chancellor or one of his subordinates. Now, refusal to appear or satisfy the decree was punished by imprisonment. Equity also created additional remedies such as specific performance and injunctions, and also recognized the interest of a beneficiary under trust. So, if you are a nephew and your father has given a property to your uncle that when you become an adult, you should your uncle should give it back to you. and your uncle refuses, and you go to the common law court, and the common law says that because the item is with your uncle, it belongs to your uncle, you can now go to the court of equity, and the court of equity is going to break it down and look at the actual issue and realize that the item does not belong to your uncle, but the item belongs to your father, and your father asks your uncle to give the item to you. So the court of equity will actually take the property from your uncle and now give it to you yourself. That is how the court of equity was working. So the court of equity started recognizing the interest of a beneficiary in a trust agreement. Now, also the chancery did not follow any binding rules, relying entirely on the chancellor's view of what is right and what is wrong. So the chancellor was just looking at things from the view of what is right and what is wrong, what is fair and what is equitable. That is what the chancellor was using, instead of using the rigid system. Now, the rigid system, it doesn't matter whether it is fair or not. If an item is with somebody, then it belongs to the person. Now, generally, you can think that the law is what, or the principle is good. However, sometimes an item can be with someone, or an item can have someone's name on it, but the item actually does not belong to the person. So the common law principles were very rigid and sometimes led to unfair outcomes. However, the chancellor didn't view it that way. The chancellor didn't have a one-way view of thought. When you come, the chancellor will break it down. And after the chancellor has broken it down, the chancellor is going to see what is fair and what is equitable. Now, when he looks at the facts and he realizes that even though the property is with you, the property actually does not belong to you, the chancellor will just pick the item and give it to the beneficiary who the item actually belongs to. So this is where there was a split between the common law and the laws of equity, even though they were all operating in England. Now, features of the court of equity. They focused on fairness and justice. They didn't just apply rigid rules. Now, because under the common law also, because the rules were rigid, some people can just do things because they know that no matter what you do, when you go to court, it is going to be in their favor, because they know the principles that are surrounding a particular case. So even if they are wrong, if the principle is in their favor, they know that the decision is going to be in their favor. However, when we go to the court of equity will look at what is fair and what is just, and then use that to apply. Also, they did not rely on writs, and the court of equity now recognized the beneficiary interest in trust, and also it introduced additional remedies such as injunctions and specific performance. Now, as a court of chancery became popular, when I say the court of chancery, I'm talking about the court of equity. So whether you see the court of chancery or you see the court of equity, it is the same thing. It's called a court of chancery because it was manned by the chancellor. It was manned by the chancellor, and then because it provided equitable decisions, it's known as the equitable or a court of equity. So whether you see the court of chancery or the court of equity, we're talking about the same court. So the court of chancery became popular. Now, this caused resentment among the common law lawyers, who argued that the quality of decisions depended on the quality of the chancellor. Now, this was also a disadvantage to the court of equity, because if the chancellor isn't a very good chancellor who can decide what is actually good and what is actually bad, and what is actually fair and what is actually unfair, it can lead to an unfair outcome, because everything now depended on the quality of the chancellor. So if the chancellor is not someone who can actually decide between what is good and what is evil, then you'll be having unfair outcomes. So that was the criticisms from the common law lawyers, that even though the court of equity is to provide fair and equitable outcomes, what if the chancellor is not a quality chancellor? What if the chancellor cannot decide on what is good and what is evil? So they were saying that the decisions now depend on the quality of the chancellor, which may lead to unfair outcomes. So that is what they were criticizing. Now, because precedents were not followed and each case were decided on its merits. So when you bring a case The chancellor look at the case and then what decide based on the fact of the present case in front of you. And because of that, the common law lawyers were worried that if the chancellor got something wrong, or if the chancellor has a misconception, it can go into the decision being made. Now, there were conflicting judgments between the common law and the Court of Chancery, because you would go to the common law, they will give you a decision, and then you go to the chancellor also give you a decision, which is what? Conflicted. Now, these cases were presented to the court, and the court said that where there's a conflict, equity shall prevail. So where there's a conflict, equity shall prevail. So if there's a conflict between the common law and the Court of Chancery, then it means that the Court of Chancery, being the equity, is what is going to what? Prevail. Now this went on until the court decided to merge the two together. So this rivalry continued for some time, but gradually it reduced as the equity also began to be ruled by precedents and standard principles. So even though the Court of Equity just started because of the conscience of the chancellor, they started standardizing it to make sure that, okay, so the chancellor said this. That means that the chancellor's idea can be applied in subsequent cases. So they started standardizing the laws of equity as well. And that also took shape in the form of the common law. So the rivalry was reducing as time was going on. Now, as equity took the shape of the common law with recognized principles and precedents, the Judicature Act of 73 to 75 was passed. And it provided that equity and common laws could both be administered by all courts. So now a court can administer a common law, a principle, and an equitable principle, because it was now being standardized. And because it is standardized, I can now look at the case being manned by the chancellor, and then I can apply the same principles in a court. So they started having the court man all the two cases or all the two principles together. Now they did not fuse them together, but they made sure that they cannot administer both the common law and the equity. So they didn't merge the common law and equity principles together, no. But they just made sure that if you bring your case and it's surrounded by common law, the court can hear it, and also if it needs equitable principles, the court can administer equitable principles. So there's still a body of equity that is distinct from the common law. Even though nowadays, even in Ghana here, we've adopted a common law, and also the principles of equity also guides us. Sometimes it comes together, and then we use them together, but they are very distinct from each other. So, however, even though they are not the same, the courts can administer both. Now, equity created maxims that had to be satisfied before equitable rules could be applied. So if you are going to court and you want equitable rules to be applied, then they set certain maxims that you must satisfy before the court will now start applying equitable principles. Other than that, you would be met with the common law principles. So one of such maxims were such that equity follows the law, but not slavishly. This means that the law will first apply the common law, but where the application of the common law leads to injustice, then equity shall prevail. So even though the court is going to apply common law, if it leads to an injustice, then they are going to now use equitable principles. So, for example, as we've already seen, equity follows the law. That means that they are going to follow the law for you. That's use the common law for you. However, if it ends up that the principles being applied leads to an unjust or an injustice, then they are going to now apply the equity. So, for example, going back to the example that I gave with the trust example, if you go to the court and then they decide to use the common law principle, you realize that it will lead to an injustice. So after they find out that, oh, you are the actual beneficiary, then they can now move on to and they now use the equitable principles to find an equitable decision for you. So we'll just go through a few examples of equity or the equity maxims that must be satisfied before the max or before the rules of equity were what applied. So examples of these are what? One, equity does not suffer a wrong without a remedy. That means that if you wrong someone, you must what? Remedy the situation. It can be cash, it can be any other thing. However, the person must get some sort of compensation or some sort of satisfaction if you wrong the person. Two, he who comes to equity must come with clean hands. If you are going to equity, so if you are going to court and you want them to apply equitable rules, you must make sure that your hands are not dirty. This joke that usually goes around that if you use counterfeit to go and buy weed, or you are selling weed and someone buys it with counterfeit, how can you sue the person in court? Because you yourself, whatever you are selling is illegal. So if you want to go to court, you must make sure that you are coming with clean hands. If you are going to court and you want the court to apply equitable rules, you must make sure that you go in there, your hands are not tainted with what? Wrongdoings. So like the just example that I gave, if you are selling weed and someone uses counterfeit to buy it, you cannot see the person for the person, cannot see the person using counterfeit, because when you go there, the weed itself that you are selling is what? Illegal. So if you want to go to equity, you must go with clean hands. Also, equity aids the vigilant and not the indolent. So equity will only aid you if you are vigilant enough, if you did everything that you should have done, if you present your case in court as soon as what possible. However, equity is not going to aid someone who is lazy or someone who didn't take very good care of whatever was happening to them. So an example is where equity, where delay defeats equity. That means that you can have a case that under normal circumstances you would have won. However, if you don't present the case to court as quickly as possible, if you do not present the case as quickly as possible, when you go to court, the court is going to tell you that the case could have been in your favor. However, because you did not present the case early, delay has defeated your equity. So equity would always aid the vigilant. That means that the one who took very good care of whatever circumstance was going on. But equity is not going to aid the indolent. If you are lazy, if you do not present your case early to court, then the court or equity is not going to aid you. Now, when we talk about these delay defeating equity, it can be found in the statute of limitation. It can be found in the statute of limitation. Now, in the statute of limitations, in Ghana, certain rules or certain laws are provided that if, for example, there's an issue, you must submit within 3 years. After 3 years, if the statute of limitation pass, then you cannot sue again. Now, these things are in relation to mostly civil law. What I'm talking about is civil law. We'll get to the distinction between civil law and criminal law soon. But most of the things I'm talking about are civil law. Most of the time, crime does not expire, especially serious crimes, they do not expire. So if you do something that is a crime, and someone doesn't sue you, and then they come later and they have evidence, they can still sue you. The only difference is that sometimes, as long as the case takes long, then evidence now decide to get missing, or evidence can be tampered with. However, serious crimes do not expire. Serious crimes do not expire. We'll be going to civil law and criminal law, so that is where you will know the difference between civil laws and then criminal laws. However, under these equity aiding the vigilant and not the indolent, and under it, we haven't delay defeating equity. Sometimes, even if there is delay and it's a serious crime, delay is not going to defeat the equity. But the only disadvantage is that as a crime takes long, evidence now happen, evidence become weaker, or evidence can disappear. And sometimes also you can forget certain things. Sometimes you can forget certain things. However, serious crimes do not expire. So sometimes if we are talking about these delayed defeating equity, it doesn't apply mostly to serious criminal issues. All right. Now, also, equality is equity. Equality is equity. Now, under normal circumstances, if if you are to share something, equity is going to share it equally, unless there's a reason not to share equally. I take it again. If there is some sharing to be done, the court is first going to make sure that they share the items equally, unless there is a reason not to share the item equally. That means that if you go to court and they realize that, okay, so the item belongs to the two of you, or there should be a split between something, the court is first going to make sure that they split it equally, unless there is a reason. For example, if it's a business that you went into, and then there's profit, and then you are fighting over the profit. Now, when you go to court and you're fighting over the profit, the court is going to first apply the fact that equality is equity. That means that if there is no other basis to divide the profit, then let's divide the profit equally, and then what? Everybody gets the part and everybody goes home. But if there are other bases, for example, once you were starting the business, you brought 70% and the other person brought 30%. And then as the business was also going on, you were involved more in the business as compared to the other person. Then the law is not going to now share it equally anymore. So if there are other bases for for something to be shared, then it is not going to be shared equally. But all things being equal under normal circumstances, if there are no bases, then the court is going to assume that equality is equity, and the law is going to share it equally. The court is going to share it equally. Next, we have he who seeks equity must do equity. He who seeks equity must do equity. That means that if you are going for equity, you must make sure that you've done your part of the of the bargain. You've done your part of the bargain. Other than that, the court is not going to mind you. So, before you go to court, you must make sure that you have done whatever you are supposed to do. For example, you've asked me to do something for you. You are supposed to pay me half. I do it, and then you pay me the other half. Now, you've not paid me the half, and I haven't worked. You rather now want to see me that you've contracted me and I've decided not to work. However, you yourself, you've not done your part of the bargain by paying me the half. So in equity, we are saying that if you want to seek equity, they must make sure that you do equity. You must make sure that you do your part of the bargain before you can see the other person. Now, if you've paid me half and I've not done anything, that is where you can see me, because you've done your part of it. So he who seeks equity must do equity. Now, last but not least, now these are not exhaustive. There are other maxims of equity that you can consult and go through. Now, last but not least, we say what equity looks at intent rather than the form. Equity looks at the intention of whatever is going on rather than the form of the item. Now, sometimes some people would want to pull one over your eyes, so they may distinguish something in the form of something in the form of another thing. So, for example, they are selling something, but they want to make it in the form of higher purchase. Now, even if the contract is drafted in the form of a higher purchase, and the intention was actually to sell the item, the court is going to look at the intention behind the agreement rather than the format or the form of the agreement. So these are a few equitable rules. You can also read on the rest and get more understanding on it. Now, next we go to common law versus statutes. Common law versus statutes. Now, here we are looking at it in the modern era, looking at whether a case is or a rule is coming from the judiciary or a rule is coming from the legislature. Is it that common law is appearing here too, but the theme or the basis of the distinction is different. Now, common law refers to a substantive law and procedural rules that have been created by the judiciary through the decisions in the cases that have been heard. So if we are looking at it from this angle, then we are saying that common laws are laws that are coming from our courts. And then statutes are the ones coming from the legislature. Now, mind you, the legislature is the one tasked with making the laws in Ghana. And then the judiciary is the one tasked with interpreting the laws. And once interpreting the laws, they what? Help solve disputes. Now, when they interpret and they help solve disputes, every interpretation that they make now becomes also a law. So generally, Parliament has passed the law. But once interpreting it by the judiciary, being it the Superior Court of Judicature, once they are interpreting the laws, every interpretation that they make and based on the decision that they make, that also becomes a law. So when you view common law and statute from this angle, we are saying that common laws are laws that are made by the judiciary, and then statute law are made by Parliament through legislation. So that means that the laws that we inherited from the British, they are known as the common law, and they are what? Distinguished based on the system that we have. And then when you come to Ghana here, we are still creating common law because our courts are still making decisions, and these decisions are becoming law. So for example, if I ask, election is won at the, those of us who are a little bit older will tell me that election is won at the at the polling station. Now, yeah, thank you very much. Now, even though Parliament didn't pass this law, as the Supreme Court was interpreting it and as they were making a decision, they now came up with this law. So now it has become a law that election is what? Won at the polling station. Now, until the Supreme Court gives exceptions, or until the Supreme Court also goes ahead and what gives other rules or changes the rule, this is going to be a law that binds Ghana. So if you are going to law, even though Parliament has not written that election is won at the polling station, because the court has decided, it is now a law. This is now telling you that all decisions made by the Superior Court of Judicature are also common laws, but these are what? Recent common laws. So as Ghana is going on in the recent times, we are still generating common laws, and Parliament is also what? Generating statutes. However, if you want to compare the systems where our laws are based from, that is where you can say what? In the olden days, the British came up with a common law, and we are relying on that system of what? Common law. However, they have what? Similar implications. However, if we are distinguishing, we should distinguish between the system of law that we are basing on, even though they were also made by judges, they are what? Old laws that were imported from British or from England. That is what the common law based on the system. And then as of today too, we are generating common laws as the Superior Court of Judicature is coming up with decisions. I hope there is no confusion. All right. So if you are being asked to distinguish between a specific classification of law, you should know what we want from you based on the two that you are what? Distinguishing between. Now, we also have private and public law. Now, private laws are laws that regulate individuals. So if you have a private law, it regulates relationship between two individuals. So citizens in a country, we are regulated by what? Private law. So laws that regulate our relationship, contracts, agency, all of these are what? Private laws. These things, when they come around, I sue you, you sue me. These are what? Private laws. But when it comes to the public law, they are matters between the state and the individual. Matters between the state and the individual. So all the laws that govern the state and the individuals, we are looking at it from a point of what? The public law. So when you pick the tax law, it is regulating the state and the individual. You pick the criminal law, regulating the state and the individual. You also pick, for example, the Constitution. It regulates the state and the individual. So these are what? Two distinct laws when they are being what? Contrasted. We have the private law and the public law. One regulating relationship among the individuals, that's among the citizens in the country, and one regulating the relationship between the state and the citizens. The first one is a private law among citizens, and the public law among the states and the citizens. Now, next we go to civil and criminal law. Civil and criminal law. Now, when it comes to civil and criminal law, it looks at the fact of the decision or the process that is being taken by the court. Now, generally, all private laws go through civil laws. That means that when you say a civil law, we are talking about a law that its remedy is not to punish. A law that its remedy is not to punish. The remedy is to give what? A compensation to the other party. But when it comes to criminal law, a criminal law is where you've gone and changed something in the criminal code, or you've committed a crime. And the idea here is to punish you. The idea here is to punish you. So, usually when it comes to private laws, most private laws go through the civil law system. Some public laws can go through the civil law system, but when it comes to criminal crimes, all crimes go through the criminal law. So there can be some public laws where they can have or where they can go through the civil law system, which is fair. However, if it is actually you committing a crime, so for example, the tax laws, if you evade tax, that now becomes a crime, and then what? It is now what? Handled through the criminal process. So when it's a civil issue, the civil issue, you sue the person. The civil issue, you sue the person. But when it comes to a criminal issue, the state prosecutes the person. So civil law is not meant to punish, but it's meant to what? Compensate. And then what? Criminal law is meant to punish. And then also when it comes to civil law, you sue the person. But when it comes to criminal law, the state is going to what? Prosecute the person. So when someone commits a crime against you, you would have to lodge it with the police, and the police is going to take it off. And then now the state is going to prosecute the person on your behalf. So when it comes to criminal issues, you would have to what? Leave it to the state, for the state to prosecute on your behalf. And the idea behind it is that they want to what? Punish you, so that you do not what? Commit the crime again, so that you do not repeat the crime again, or to also serve as a deterrent for other people not to what? Commit those crimes. So civil law doesn't seek to punish, it seems to compensate the injured party, but criminal laws seeks to punish. Criminal law seeks to punish. However, there can be one case that can cut across civil law and criminal law. So as the state is what? Prosecuting the person on your behalf, you can also sue the person for compensation. So for example, if someone beats you up, someone assaults you, you can lodge a criminal complaint and the person is going to be punished by the court. However, you can also what? Launch a civil a civil suit against the person, where what? You can what? Claim things to what? Help you recover. So you can what? Claim what? Compensation. So you can have one case cutting through civil and what? Criminal laws. So just one case cutting through civil and criminal law. But make sure that you understand that the criminal element seeks to punish the person and to make sure that the state handles the person. And then when it comes to civil issues are just what? To compensate the person for whatever you've done to the person. Now, when it comes to proving, civil law, you just prove on a what? Balance of probability. That means that you just have to make sure that your evidence or whatever you are saying outweighs the other party. That is where you win in a civil law. Civil law based on what? A balance of probability. So just what? Having more than the person is enough. But when it comes to criminal law, you have to prove beyond reasonable doubts. You have to prove beyond reasonable doubt, because the criminal law seeks to punish the person. You cannot just accuse someone and then what? The law is just going to what? Punish them. So for there to be an actual punishment, you have to what? Prove beyond reasonable that the person actually did it. Now that is why sometimes some people just walk away even though they've committed a crime, because there isn't enough evidence to what? Show beyond reasonable doubt. If you are saying we are showing beyond reasonable doubt, we are talking about the evidence that when we put in front of everybody, almost everybody will be convinced that this person committed a crime. So just knowing that someone committed a crime is not enough. You must make sure that you can prove beyond reasonable doubt that the person actually committed a crime. So these are the basic distinctions between a civil law and a criminal law. So civil law is a form of a private law, and it involves relationship between individuals. It is a legal mechanism through which individuals can assert claims against one another through rights adjudicated and enforced. The purpose of a civil law is to settle disputes between individuals and to provide remedies. It is not concerned with punishment. However, criminal law involves the enforcement of a particular form of behavior, and the state, as a representative of the society, acts positively to ensure compliance. So the state is going to prosecute on your behalf and make sure that if the person is guilty, the person is punished. Next, you go to municipal laws and international laws. So we can have municipal laws, you can have local laws, even you can have country-wide laws, and you can have international laws. Now, municipal laws are local laws that govern us. You can even have laws at the at the country level. Now we distinguish from the international laws. Now, international laws are laws that regulate sovereign countries. It regulates the relationship between countries and another. Whilst municipal and then other local laws govern the relationship among us at the municipal level, and if it's at the countrywide level, those regulates the relationship in a particular country. But international laws regulate individuals regulate states, a relationship between states. So, for example, UN directives and orders and conventions. That is why one country cannot just get up and do other things to another country. So there are directives that are put in place to ensure international peace. Next, we have substantive law and a procedural law. Now, substantive law are the laws that governs a particular issue. They give out the rights, they give out the responsibilities, they give out everything. If they give out the punishment that is supposed to go with a particular law. But the procedural laws are the laws that prescribe the modes through which things are done. So an example of the substantive law is the criminal law. The criminal law is going to tell you the crime, is going to tell you the punishment that is attached to the crime, and the rights awarded to the people who also commit the crime. So the criminal law is a substantive law because it prescribes or it governs a particular issue. Now, the criminal procedural code, it tells us that after someone has been caught or someone has been accused of a crime, now, what are the processes that we have to go through in order to prosecute the person? That now becomes a procedural law. So substantive law tells us what the crime is, what the punishment that is attached to the crime, and what the rights also afforded to the person. While the procedural law talks about if someone commits a crime, the person is being arrested, or the person is being arraigned, the process or the procedures that we should use in order to prosecute the person. That is known as the procedural law. And an example is the criminal procedural code. Now, sources of law. Generally, sources of law. Now, laws come from somewhere. In every society, people know where the laws come from. In Ghana, we know where the laws come from. We know parliament can make a law. We know the president, the ministers can make a law. Even at the agency level, we know that agencies can also make rules that are binding on us. So in a country, we have an idea of where the laws come from. And as I've already given an example, I cannot make a law. So you know that definitely if I say something, it is not binding on every citizen in Ghana. Now, anyone at all. Okay, so now people can differentiate between a law and a mere statement, which does not give the force of the law. Like I said, if anyone gets up and anyone says anything, it is not a law. But if the people who we know can make laws say something, then we know that that is legitimate and we are binded by those statements. So anyone at all cannot get up in a society and decide to make a law. The person ought to have certain power and authority to be able to make a law in the society. So before you're able to make a law, you must have what? A backing, or you must have some sort of power or authority. Now, every society has a way of identifying what really is what acceptable as law. In Ghana here, we know what's acceptable as law. According to Bimpombuta, source of law means the place from which laws originate and gives it binding force. So if a law originates from somewhere and it is also giving it a binding force, then we are saying that that place is what? An authority that can give us a law. So in Ghana here, these are the various sources of law that we have in Ghana here. If a law does not fall within this, then we are saying that that law is not a law in Ghana. So one, the 1992 Constitution itself is a law in Ghana. Now, this is the supreme law of the land. Every law must not contradict with this law. Now, this law gives general provisions, and based on that, Parliament can come up with other laws. And when Parliaments are coming up with other laws, we are saying that it should not contradict the 1992 Constitution. So this is the supreme law of the land, and every law that's every law that comes after this 1992 Constitution must not contradict the 1992 Constitution. Now, any law that contradicts the 1992 Constitution ceases to become a law. Any law that contradicts the 1992 Constitution ceases to become a law. So any law that Parliament is making, the President is every other person is making, we must make sure that it's what aligns with the 1992 Constitution. And because it is the supreme law of the land, if you try to abrogate it, then the punishment or the crime that you've committed is high treason, the highest crime of the on the land. So the 1992 Constitution itself has made provision that anyone who tries to abrogate, when we say abrogate, anyone who tries to overthrow the 1992 Constitution commits high treason. Now, high treason, the punishment for high treason is death. The punishment for high treason is death, the highest crime of the land. So anyone who tries to commit high treason, that is by overthrowing the 1992 Constitution, the punishment is death. Now, even though Ghana has now gone under, or Ghana has now decided that they are not going to go along with the capital punishment, that is a death penalty, because it has certain disadvantages. Because sometimes you believe someone has committed a crime, you go into it, and then there's a death penalty, the person dies, and then now find out that the person wasn't the one who murdered the person. So because of that, there were a lot of disadvantages when it comes to the capital punishment. Even though certain states in the US are still practicing it, in Ghana here, we've abolished the death penalty. Certain states have also abolished the death penalty in the US and other parts of the world. Now, it was so because if you find out that someone actually did not commit a crime, you cannot bring them back from the dead. But if there is life imprisonment and you find out that the person didn't commit a crime, then you can now decide to bring the person out of prison and even compensate the person in that regard. That is why these sort of death penalties have been abolished. However, because the 1992 Constitution is the highest law of the land, the punishment for high treason is death in the 1992 Constitution. So unless there's an amendment in the 1992 Constitution to cater for the abolishment of the death penalty, as of now, it still stands that if anyone tries a coup to abrogate the 1992 Constitution, then the person is liable for high treason, and the punishment is death. Now, so like I said, the 1992 Constitution is the supreme law of the land. It even establishes a lot of things. It establishes the multi-party system. That is why we cannot have only one party in Ghana. Last election, when we counted, I think there were 18 before, some were disqualified, and then they even got a smaller number. So the 1992 Constitution gives out the basic rules and from that we can what make up what other laws. Now, the next source of law is from the parliament. The next source of law is from the parliament. Now, the parliament has been given the power to make laws. So they are what? Primarily, they're the one who are tasked with the laws of Ghana. So from the constitution, we move on to what? The parliament. So the constitution itself is a source of law in Ghana. And then after, it has given provision that parliament can enact the what? Laws that originate from the constitution, because the constitution does not cover everything. It may be broad, it may cover certain aspects of it. However, it does not cover everything. So parliament is the one who is going to now what enact what specific laws in what that regard. That is why it has given parliament the power to do that. And then laws made by parliament are known as what? Legislature, acts of parliament, statutes. They are all what? Interchangeable. Now, next we have some other people who are not part of parliament, but they can still make laws. That is because the 1992 Constitution has given them the power to make these laws. So we have any orders, rules, and regulations made by any other person or authority under the power conferred by the Constitution. So we can have the Electoral Commission making a law. You can have the president making a law. Even the minister can make a law. The minister can make a law. That is why when the minister, the previous government, when they read the budget, they went to the parliament, and then what? In the budget, there was what? A law known as what? The e-levy. And as the budget was passed, the e-levy was also what? Passed. Even though there was some back and forth, they went to court. However, it was still decided that what, the e-levy was not unconstitutional. So because of that, they could what? Pass the e-levy. So the minister can also what? Make a law. And even tripling down, we can have what? Other agencies also what? Coming up with laws, such as the what? Electoral Commission. They can also what? Make a law. However, these orders, rules, and regulations must be laid before parliament. These orders, rules, and regulations must be laid before parliament for parliament to what? Reject it. Now, if parliament does not reject it, then it means that parliament has what? Approved it, and based on that, the law holds. Based on that, the law holds. Now, if parliament wants to reject it, then parliament must make sure that they have 2/3. So parliament can reject it by 2/3. Parliament can reject it by 2/3. Also, if it is sent to parliament and within 21 days it hasn't been rejected, then it comes in force as a law. It comes in force as a law. So if parliament is to what? Reject it, and parliament does not reject it, then it becomes a law. Now, going back also, if parliament comes up with a law, you have to make sure that they also send it to the president for the president to what? Assent it. So what? Accent it, put his accent on it. So if parliament comes up with a law, it becomes a bill until the president signs it. And also, any other person who is making a law, they must put it what? In front of parliament for parliament to what? Approve it. Now, if parliament does not want to approve it, then they have to reject it by 2/3. However, if nothing is done about it, then after 21 days, automatically the laws are what? Are passed. Automatically the rules being submitted are what? Passed. So these are what? Also known as what? Subsequent legislation, these are known as what? Subsidiary. So subsidiary laws made by what? Other parties who are not parliament. Other parties who are not parliament. Now next, I know we are okay. Someone said they cannot see my screen. Obna said he cannot see my screen. Any other person?
Yes, I can
Is there
see
any other
it.
person who cannot see my screen?
Yes, I can see it.
Can you see?
Sources of law of Ghana. I can see it.
Yes.
No,
So
it's
if
wrong.
I can also see.
So if some can see it, and some cannot see it, then we are saying that, or it means that it is your network. So you can just log out and then rejoin. So you can just end the call and rejoin and see whether you would say it. Just do that quickly. Do that quickly and then let's see. Just do that quickly. Let's continue. All right. So can you see it now? I don't know whether they are back, but can you see it now?
Yeah, I can see now.
All right. Thank you very much. Now, we go to the next one, which is known as the existing laws. Now, before the 1992 Constitution came about, there were some laws that were already existing. Now, these laws were not cancelled. These laws are still in force. So we are saying that if there's an existing law that does not contradict the 1992 Constitution and also hasn't been replaced by any subsequent legislation, then that existing law is also what is recognized as what a law in Ghana. I take it again. If before the 1992 Constitution there was a law operating in Ghana, and that law does not contradict the 1992 Constitution, and that law also has not been replaced by the has not been replaced by any subsequent legislature, then that becomes an existing law. So, for example, we have the Contracts Act. Now, the Contracts Act was brought about in 1960. 1960 is before the 1992 Constitution. So here, the Contracts Act becomes an example of the existing law. Now, there's a difference between replacing an act and amending an act. If an act has been amended recently, it has not been replaced. So it is still known as an existing law. So because we've had amendments of the Contract Act, but amendment does not mean replacement. So there's a difference between amendment and replacement. So we have what amendment of the Contract Act, but it is still the Contract Act of 1960, and that makes it an existing law. Now, another example that I can give you is the Companies Act. Now, the Companies Act was brought in about in 1963, but it has been replaced by a subsequent legislature in 2019. So before 2019, the Companies Act was an existing law. However, it ceased to be an existing law in 2019 because it has been replaced by a subsequent legislature. So as of today, the Contract Act is still an existing law, but the Companies Act is no longer an existing law, but it is now an enactment made by Parliament. So the basis of what I'm saying is that an existing law is a law that came into being before the 1992 Constitution. Now, these laws should not contradict the 1992 Constitution. These laws should not contradict the 1992 Constitution, and also should not be replaced by any subsequent legislature. If any of these things apply, then those laws are not existing laws. If the law contradicts the 1992 Constitution, it ceases to be a law, and also if it has been replaced, also it ceases to be an existing law. Now, but one thing is that sometimes certain portions can contradict the 1992 Constitution, and certain portions do not contradict. Now, the portions that contradict now do not hold as a law in Ghana, while the portions that the portions that contradict do not hold, while the portions that do not contradict now hold as law in Ghana. So if you pick an existing law, you pick any other law, and some part of it contradicts the 1992 Constitution, that part that contradicts is not recognized as a law in Ghana. It's only the parts that do not contradict that are recognized as a law in Ghana. So we are saying that existing laws are laws that came before the 1992 Constitution, and they are also laws in Ghana that we use them today, except that before we use them, we must make sure that they do not contradict the 1992 Constitution, and also they have not been replaced by any subsequent legislature. Now, next we have the common law. Now, the common law is a broad law in the 1992 Constitution. Now, the 1992 Constitution has disaggregated the common law to mean one, the common law and the laws of equity that we inherited from the British. That means that the laws that we inherited from the British are still in force in Ghana here. So the common law is what a broad topic as a source of law in Ghana. Now, whilst breaking it down, we recognize the common laws inherited from the British and the laws of equity also inherited from the British. Now, with the common law and the laws of equity that we inherited from the British, it also has caveats. The caveat is that one, it should not contradict the 1992 Constitution, and also it should not contradict any Ghanaian law. So if a common law principle contradicts the Ghanaian law, then we are saying that that common law ceases to be recognized in Ghana. So in Ghana, we only go with common laws that has been inherited from the British. We only go with common laws that do not contradict with any Ghanaian law. So if there has been no subsequent principle in that nature, then we would adopt the common law principle and then we will apply it in Ghana. Now, if there has been a subsequent legislature and it is not in contradiction, that means that the subsequent legislature agrees with the common law, then we can use the principles hand in hand. However, if the Ghanaian law contradicts with the common law, then that common law does not operate in Ghana. Then anytime that we want to read that principle, we would only read what the Ghanaian law to get the principle to work in Ghana. So that's the caveat for the common law and the laws of equity that was inherited from the English or the British. Now, next, we have the customary laws. Now, customary laws are usually with what? Societies, what? Small societies. Now, these customary laws are also laws in Ghana that are recognized. Now, these customary laws, you must make sure that it also does not contradict the 1992 Constitution. Because as we know, some customary laws contradict the 1992 Constitution and they are very barbaric. So those barbaric customary laws are not enforceable in Ghana. However, other customary laws that are not barbaric and do not contradict the 1992 Constitutions can be enforced in Ghana. So we have certain laws that we enforce in our society, in our villages. Do not go in Accra, do not go to the sea on, I think it's a Monday or Tuesday. In certain places, they don't go to the farm on Thursday. Now, if the king or the chief catches you going to farm and he punishes you, you will what? Do the punishment. Because these customary laws are enforceable in Ghana. However, you must make sure that the customary laws are not barbaric and also they do not contradict the 1992 Constitution. And one important aspect of the 1992 Constitution is the fundamental human rights. The fundamental human rights. So some customary laws are what? Very what? Barbaric, and they infringe on people's rights, especially the women. Especially the women. Now, these laws cannot be enforced in Ghana. For example, these female genital mutilation, those laws cannot be enforced in Ghana. Also, these widowhood rights that they used to do, the widowhood rights, those ones are all what? Archaic. Where I think the witches camp and all of those things, all of those customary laws cease, they are not recognized as a law by the Constitution. Even nowadays, they've started modernizing certain aspects of the customary laws in order to what? Suit the changing trends. So I even heard that, I think, is it Depot? So at first, they used to just go topless, but now at least they cover certain aspects and then they make sure that it is what? Civil. So all I'm saying is that when it comes to customary laws are recognized only if they are not barbaric and they do not contradict the 1992 Constitution, especially if they do not infringe on people's rights. Then we are saying that that customary law is recognized as a law under the 1992 Constitution. And also the common law is also made up of what? Subsequent decisions by the Superior Court of Judicature. So there's the decisions made by the Superior Court of Judicature are also form part of the what? Common law. I remember in the definition of the common law versus the statute, it was there. So under the broad umbrella of common law, it is also part of it here as an example of the common law. Now we are supposed to break for 10 minutes. We would break, and then I think by 10:22 we would come back. Or you want us to continue? You don't want any break? Hello?
Let's break for 10 minutes.
All right, so let's break. This one we don't even need to hang up. So just break. Maybe you want to take water, you want to take something. Let's break for 10 minutes. And when we come back, we would continue. But before we go, these are the laws that we have in Ghana. Any laws that do not find themselves here are not laws in Ghana, or they are not recognizable laws in Ghana. That means that the president of Togo cannot make a law for us. All right, so let's break and then we'll come back and continue. All right, so I hope we are all back. Hello, I hope you are all here.
Not all.
Hello. Not all. Let them come
Yes,
back.
sir. Not
I
all.
told them not
Oh,
to. Oh, I told you people not to go off, and he went off. Were we supposed to come back at 9:22? But it is now 9:25. I
I'll
gave
quickly
additional
inform
3
them.
hours. 3 minutes. Yeah, they shouldn't have, because 10 minutes wouldn't do anything to your data. Okay, so before they come, how many meetings are we having? Anyone, like, how many meetings are we having?
Yeah, it's supposed to be about 4 times
4
in a week.
meetings.
Yes, please.
4 meetings in a it's 4 hours
No,
in a
not
week. But how
not
many weeks?
for 4 hours in a week, but the week
Yeah, 4 hours.
I think we go like 4 weeks.
Really?
So in
I
each
thought it
week
was
is
6.
one. The other ones, I think we have one for revision.
Okay.
Mm.
All right, so you don't worry about it. All right. So kindly inform them that we are about to start.
Okay.
All right, let's start. Okay, so let's continue, and then when they come, they just join us. All right, so these are the laws in Ghana, and if any law does not find itself here, then it is not applicable in Ghana. However, we have international laws, as we've already done in the classifications, and these international laws and treaties, if Ghana signs them, then Ghana is bounded by these laws. However, for there to be these, for these treaties to be binding on us under Article 75, the president must first sign it. The president must first sign it, and then the parliament must agree to it. That means the parliament must pass on it. So when the president signs it and it comes to parliament, and they either pass a bill or they sign it, then that is where these international treaties become binding on us. Other than that, either than that, these international treaties do not become binding on us. So Ghana, we are under UN, we are under AU, we are under ECOWAS. When they pass any treaties or they pass any agreements that Ghana wants to agree with, the president signs it, it brings it back to Parliament, and then Parliament will either pass a bill on it or Parliament will vote, and then when there is a majority, then that treaty now binds us. So that is how international law works. But you see that even with the international laws, it still passes through these sources of law that we have. That is the president having to bring it down, either the president or either the foreign minister. So it depends on, so the president can assign the foreign minister, but the president must be the one to sign, and then it comes down to Parliament for Parliament to vote on it and what agree for it to be passed. So the laws in Ghana comprise of law that can be traced down. I think the projection has stopped moving again. I don't know whether it's the network. Okay. All right, so I think it's working again. All right. So the above sources comprise of any, so the laws of Ghana comprise of any law which can be traced from the above source. If a law cannot be said to have come from any of these sources, then this law is not binding in Ghana. So if a law doesn't come from any of the above sources, that is from the constitution itself, from legislation, from any other person like the president, electoral commission, the ministers, also if the law is not an existing law or the law is not under the common law, I'm talking about the broad common law, then that law is not existing, or that law is not seen as a law. Are the sources of law in Ghana, where Ghana gets its law from. So any principle that is being binding on us must at least find its way into that, or must come from any of these five sources. Any law that you can mention, that you can think of, that binds us in Ghana comes from these five sources. That means that if a law is in Ghana or something is said to be a law in Ghana and we cannot trace it from these five sources, then it is not binding on us in Ghana. All right, so next we go to the sources of business law. Now that we've established the laws that binds the whole of Ghana, let's break it down into business law. So as businessmen and women, what are the laws that binds us? As business laws and women, what are the laws that binds us? So one, we have agency law. Now, agency law, we do not have the complete agency act in Ghana. So we still rely on the common law principles. As I've already mentioned, the common law principles are still applicable here. And this is supported by the Contracts Act. So there are certain agreements that are supported by the Contracts Act. The Contract Act takes care of certain agreements and agencies. So it is the common law principles supported by the Contracts Act. Then go to the sale of goods law. The sale of goods law is governed by the Sale of Goods Act of 1962, Act 137. This also becomes an existing law by the definition that I gave earlier. This becomes an existing law. So the sale of goods in Ghana is governed by the Sale of Goods Act. Carriage by land is governed by the common law principles supported by the Contracts Act. And then we have carriage by sea and then merchant shipping. These laws are governed by the Bill of Lading and then the Merchant Shipping Act. Now, terms of guarantee, we do not have a guarantee act. However, we infer from the common law principles and also is supported by the Contracts Act. Insurance law is governed by the Insurance Act 2021-1060. We have the Bill of Exchange Act law being governed by the Bill of Exchange Act of 1961, Act 55. Now, all of these are business law, but as I've already mentioned, we'll just be going through some of them and not all of them. Now, we also have the partnership law. Partnership law is being governed by the Incorporated Partnership Act. We have the company law being governed by the Companies Act. Excuse me. Sorry. We have the Companies Law being governed by the Companies Act 2019 Act 992. Then we have the Employment and Labor Law governed by the Labor Act 2003 Act 651. We have the Criminal Law governed by the Criminal Offences Act 1960 Act 29. We have the Hire Purchase Law governed by the Hire Purchase Act NRDC 292 of 1974. And then we have conditional sales also being governed by the Hire Purchase Act. And then we have tort law. Tort law is being governed by the common law principles. We have land law being governed by the Land Act. We have Bill of Lading governed by the Bill of Lading Act. And then we have law on trust being governed by the Trustee Act of 1962. And then we have negotiable instruments being governed by the Bill of Exchange Act 1961. So these are some few examples of business laws and then where they derive or the acts that they are. Sorry, or the acts that guides them. Now we go to the Ghanaian legal system. Now the Ghanaian legal system, before we go there, let's look at what a legal system is. So legal system refers to a set of laws, institutions, and procedures, and a combination of them which make up the whole law for a given society. So this includes the legislature, the interpretive institution. When I mention the interpretive institution, you know I'm talking about the courts. So the interpretive institution and their procedure, and the executing institutions and their procedures. So executive institution, I'm talking about the executive. In addition to the cultural and customary rules that exist in a particular society. So even though we have our formalized rules that govern the whole of Ghana, each society, they also have their own customary laws. So Ghana's law is heavily influenced by the common law, as I've already mentioned. So it has been heavily influenced by the common law, which we inherited from the Britain under the common law system. Now, it is the British law system together with our local customs and practices of the people that has come together to make up our current legal system that we have in Ghana. So we've already done the history of the Britain, where we said that when William the Conqueror conquered them in 1066, that is where he sent out judges for the judges to go and help solve issues. And based on that, they came up with a common law. And these common laws were exported towards the colonies, which Ghana was inclusive of. So the common law that was exported, Ghana was also inclusive. And then based on that, our laws has been heavily based on the common law, in addition to our customary laws. So there are some laws that are being made or that can trace its way because of our custom and how we do our things. That is why in the outside world, a man and a man can get married. But here we say in our customs, a man marries a woman. So if this anti-LGBTQ law passes, we would realize that we will now criminalize these relations between man and woman and woman. So these are some of the ideas that we get when we say that our laws are heavily reliant on our customs. So sometimes when you even ask someone his view on the anti-LGBTQ or whatever they are doing, you would realize that most of the time the only argument that they have is that it is not compatible with our customs. They may not have any additional ones. Some may have it for religious reasons and other reasons, but when it comes to legal reasons, you realize that they say that it is not compatible with our customs. Our customs, a man and a woman gets married, not a man and a man. So you realize that all of the laws that we have, even though it's sometimes it may not be explicit. Sometimes it may not be explicit. Sometimes you realize that some of our customary laws may creep into the laws that we make. So historical influences. Now, our forefathers practiced a chieftaincy system. Now, this chieftaincy system that they were practicing, the chief's palace became the legislator, the executive, and then the judiciary. Because the chiefs are the ones who come up with the laws. When you have an issue, you go to the chief's palace for the chief to give you a decision. And then if there's anything, the chief is going to send his executioners to make sure that you comply with whatever he's saying. So at first, the chief's palace used to be what? Both all of these three organs put together. So like I said, the palace was the legislature, judiciary, and the executive. However, on 6th March 1844, some local chiefs in the Gold Coast signed the bond of 1844. If you remember social studies, the bond of 1844. Now, it is this bond of 1844 that gave the British, or that's where they relinquished some of the duties or the judiciary duties to the British, where they recognized the power of the British and they agreed that they are going to submit some cases to the British, especially cases such as murder and robbery, to be decided based on the British law. So they signed the bond of 1844, and then what? They recognized the power of the British in the Gold Coast. And based on that, they realized that some serious criminal offenses would now be sent to the what? To the British, and then they are going to decide based on their laws and not the laws of the chieftaincy. Now, gradually, Ghana became a colony, and this persisted until what? Independence of what? 6th March 1957. So after the bond, it went on, and then at the end, Ghana became a full colony. Now, so Ghana was what? Ruled by the British and with the British laws up until 1957, where we got our independence, and then we started making our own laws. Now, meanwhile, the English laws has become part of us as we apply the laws in our principles. Now, the 1992 Constitution even recognizes the common law as part of our source of law. So even the 1992 Constitution still recognizes that common law should still be recognized as a source of law in Ghana. And by this one, they've given a caveat that it should not contradict the 1992 Constitution, and it should not also contradict any Ghanaian law. Now the lawmaking institutions in Ghana. We have the people as the supreme lawmakers. Now the people are the ones who choose the parliament, and they're the ones who choose the executive. So we are viewed primarily as the supreme lawmakers. And then when we choose these people, then they go and then they represent us. And they make the laws, they interpret the laws, and they enforce the laws on our behalf. So because all of us cannot go to parliament, we vote, and then we elect a few of them, I think 275 of them, to go and represent us in parliament. So we are the supreme lawmakers, and then we vote on these people, and these people now represent us, and they go and then they make and execute the law on our behalf. Now next, we move on to the court structure. The court structure. Now the court structure, it is broken down into two. We have the Superior Court of Judicature and then the lower courts. Superior Court of Judicature and the lower courts. I usually make this distinction so that students do not get confused. When you hear superior, that doesn't mean the rest are inferior. It is just a name given to it. So we have the Superior Court of Judicature and then the lower courts, not the inferior courts. Because mind you, these courts are not inferior. Circuit court, they can jail you. District court, they can jail you. So the fact that they are lower courts doesn't make them inferior. They are just lower as compared to the Superior Court of Judicature. That's all. So anytime that we are referring to them or we are talking about them, we should have the Superior Courts of Judicature and then the lower courts. Now, the Superior Court of Judicature is made up of the Supreme Court, Court of Appeal, and then the High Court and Regional Tribunals. And then the lower courts are made up of the Circuit Court, District Court, and the Juvenile Court. So lower courts are made up of the Circuit Court, District Court, and the Juvenile Court. Now, the lower courts are also made up of the National House of Chiefs, the Regional House of Chiefs, and other traditional councils. But because we are not discussing chieftaincy issues, I didn't bring it here. So generally, under the lower courts, we have the Circuit, District, and Juvenile Court. And then to handle chieftaincy issues, they have the National House of Chiefs, the Regional House of Chiefs, and also they have the traditional councils. So the judicial sections in all of them are recognized as a court or as a lower court in Ghana. Now their task is to look out for chieftaincy issues. So they govern chieftaincy issues. We are not going to be going much detail into the chieftaincy issues. But you see, as this order goes, usually or generally, when there's an appeal, it climbs in that particular order. Now, another thing that I want to stress on is that when I say generally, usually there's an exception. So generally there can be a rule. In law, generally there's a rule, there may be exceptions. So when I say generally, it means that most of the time these things apply, but under certain circumstances, other things may apply. So when I say generally, they move in that order. Sometimes some appeals can jump certain courts. That's what I mean. But generally, from the district move to the circuit move to the high court, and then it goes in that order. However, sometimes as we go on and we are reading, we get to see that sometimes certain appeals skip certain courts and they go to the court in front of them. So when I say general, I mean that most of the time, but sometimes there may be exceptions. So in the chieftaincy issues also, they move to the traditional councils, regional house of chiefs, national house of chiefs, and then they move straight to the Supreme Court. So their system is also quite different. So their system is like the lower courts, but from the national house of chiefs, they just move straight to the Supreme Court. They don't come through our normal court system. All right, but like I said, we will not be discussing the chieftaincy issues in Ghana, so we don't have to stress on the chieftaincy issues. We are more interested because as business people, we will be more interested in these courts. These are the courts that if there's an issue, we will be going to. Even though sometimes in some syllables they even cut the juvenile court out. I'm just bringing out the juvenile court so that we will know that there's a court in Ghana that handles children's issues. However, the juvenile court sometimes is even cut out of business law because when we're talking about business, we are talking about the other courts. All right. So let's look at them one by one. Remember, I've told you that the Superior Court of Judicature is made up of the Supreme Court, Court of Appeal, and then the High Court and regional tribunals. Now, the regional tribunals and the High Court, they are mostly on the same level. Just that sometimes the High Courts can do things that the regional tribunals cannot do. For example, prosecution for for example, having the supervisory jurisdiction. I don't want to move ahead yet, but the regional tribunals does not have the that does not have supervisory jurisdiction. This is what I'm coming. So the regional tribunals that don't have any supervisory jurisdiction, and there are certain things that the high courts can do that the regional tribunals cannot do. But one important thing is that the regional tribunals are almost non-operative in Ghana. So sometimes we usually don't discuss the regional tribunals because almost they are non-existent. They are non-functional. Most of them have been merged into the high court, and the high court now takes over everything. So the regional tribunals, they are specialized courts, but they are almost not in existence. So usually sometimes we skip them. But the constitution has them, and the court act also has them. But in practice, they are almost non-existent. Like practically, they are almost non-existent. All right. So let's begin with the Supreme Court. Now, the Supreme Court is made up of the Chief Justice and at least 9 other justices. That means that at any point in time, the Supreme Court must have 9 justices, at least, so it can be more, but at least it must have 9 justices plus the Chief Justice. Now, when they are working, they work in 5 justices. When they are working, they work in 5 justices. Now, if there's a review, we'll talk about review, but when there's a review, then they would have to add 2. Now, mind you, the court always sits in odd numbers. So we don't go to court for a draw. In court, they sit in odd numbers so that there will be a win always. So when the Supreme Court is sitting, they sit in 5 justices, and then after they vote, and the majority takes it. Now it is not compulsory that they have to sit in 5, but at least they have to be 5. That means that if there are 9 Supreme Court justices, for a case, all of the 9 of them can sit on the bench and then decide on it. For a case, all of the 9 of them can sit. We're just saying that at least if we are going to Supreme Court with a case, at least there should be 5 justices sitting on the bench. However, if there's a review case, then there should be at least 7 of them. It can be more, but at least 7 of them. Now, for you to qualify to be a Supreme Court justice, you must be someone who has high moral character and proven integrity. And also, you must have at least 15 years standing as a good lawyer. So if you have these things, then you qualify to be a Supreme Court justice. You qualify to be a Supreme Court justice. High moral character, proven integrity, and at least 15 years in good standing as a lawyer. Now, the high moral character and proven integrity cuts across almost every court. So it is the years that are important, because it doesn't matter the court that you want to man, you must have high moral character and proven integrity for you to be a justice or a judge in Ghana. So jurisdictions. When we say jurisdictions, it means that the things that the court can do. Now we have general jurisdiction and then original jurisdiction. Now general jurisdiction is something that a court can do, but other courts cannot do. And original jurisdiction is a jurisdiction where you can hear a case in the first instance. So general jurisdiction, something that you can do that other courts cannot do. And an original jurisdiction is where you can hear a case in the first instance. Sometimes for the Supreme Court, original jurisdiction and then general jurisdiction can overlap, because they are the only court that can do certain things. There are certain things that, apart from them, no other court can do. So, for example, we have the enforcement and the interpretation of the Constitution. Now, any other court can interpret any other laws, but when it comes to the Constitution, only the Supreme Court can interpret the Constitution. No other court in Ghana can interpret the Constitution. No other court in Ghana can interpret the Constitution. If they interpret the Constitution, every decision that they make is not valid. If they interpret the Constitution, any decision that they make is not valid. So if you have a case with the High Court and there's an issue of interpretation of the Constitution, the High Court would have to wait. Then they will go to the Supreme Court for the Supreme Court to interpret the Constitution before they come down and then continue with the case. If the High Court continues with the case, any decision that they come up with by interpreting the Constitution is a wrong decision. So only the Supreme Court has the original and the general jurisdiction to enforce and interpret the Constitution. 2, when it comes to whether Parliament has made a decision or has enacted an act in excess, only the Supreme Court can check whether Parliament has made an act that is in excess of their powers or that contradicts the Constitution. So, for example, you remember the e-levy, they sent it to court that it was unconstitutional, but the court ruled that it was not unconstitutional, and then it's passed. Now, had the court ruled that it is unconstitutional, the e-levy wouldn't have been passed. So one thing is that the Supreme Court can stop the Parliament from passing an act if the act is in excess of what they have to do, or if it contradicts the Constitution, and if it is unconstitutional. Now, you remember the anti-LGBTQ. It was passed by Parliament, but before it was assented by the President, it was sent to court to challenge the constitutionality of the anti-LGBTQ. Now, even though some people can say it is politics, some people can say it is other things, it is now left with the Supreme Court to say that the anti-LGBTQ Act is constitutional or it is not constitutional. Now, even though they've given, I think, what's the name? An undefined leave, and then they've just postponed it indefinitely. If the Supreme Court comes today and they say that the anti-LGBTQ is constitutional, then it will pass. And when it passes, that means that we've criminalized homosexuality in Ghana. But if the Supreme Court comes out and they say that the anti-LGBTQ is not constitutional, That means that if it infringes on the right of same-sex marriage or same-sex relations, then it means that we cannot criminalize homosexuality in Ghana. So now it is now the power is with the what Supreme Court, and that is the power that they have. That if Parliament comes up with a law, you can challenge Parliament in the Supreme Court to see whether the law is constitutional or the law is not constitutional, and only the Supreme Court can do that. You cannot challenge an act of Parliament in any other court than the Supreme Court. Now, next they have appellate jurisdiction. Appellate jurisdiction. Now, appellate jurisdiction is the right to hear a case that has been heard by a lower court. So if a court is lower than them and they hear a case, then if you're not satisfied, you'd have to come to the Supreme Court for the Supreme Court to give you a decision. So that's the appellate jurisdiction. Now, generally, they receive appeals from the Court of Appeal. But under special circumstances, they can the Court of Appeal can grant a leave, and then an appeal can jump straight from the High Court to the Supreme Court. But generally, they hear appeals from the Court of Appeal. But under some circumstances, some appeals can jump from the High Court and then move straight to the Supreme Court. Now, they are the final Court of Appeal in Ghana. Sometimes I'm starting to make mistakes of assuming that the Supreme Court is not the final court and the Court of Appeal is the final court. Now, the Court of Appeal is a court for appeals. However, when we say a final Court of Appeal, it is not the name of the court, it is an attribute of the court, which means that after you go to the Supreme Court and you lose, there is no way in Ghana that you can take the case again. If you go to the Supreme Court and you lose, there is no way in Ghana that you can take the case again. That is why in Ghana here, the Supreme Court is the final Court of Appeal. That doesn't mean that is the name, it's just an attribute of the Supreme Court. And it's not the same as the Court of Appeal, which is the actual name of the court. Now, it also has review jurisdiction. I've already mentioned review, but let's break it down now. Now, review is where they sit on their own case to see whether the case was valid or the decision was valid. And they can decide to either cancel the decision that they have made or uphold the decision that they've made. No other court in Ghana has a review jurisdiction. That means that if you have a case in the circuit court, it moves to the High Court, it moves to the Court of Appeal and the Supreme Court. You cannot send one case twice to the High Court. So if you go to the High Court and you're not satisfied, you cannot go back to the High Court. You'd have to go to the Court of Appeal. However, when you go to the Supreme Court, because it's the final Court of Appeal, after that, you cannot go anywhere again. So if you want them to review your case, then you have to go back to them, and then they will see whether they will review or not. And even if they review, they will see whether they are going to depart from their decision or they are going to stand by their decision. That is why I said in an original case, at least there should be 5, but in a review case, at least there should be 7. So it means that in a review case, they add 2 people to them for it to be 7, for them to have a review jurisdiction. So a review is where they themselves are hearing a case that they've already heard. That means having a second look at the case that they've already heard. But appellate jurisdiction is where they rehear a case from a lower court. And some courts may have appellate jurisdiction. For example, Court of Appeal has an appellate jurisdiction. The High Court has an appellate jurisdiction. Even the Circuit Court has appellate jurisdiction. But with a review jurisdiction, only the Supreme Court has a review jurisdiction, because they're the only court that can sit on a case that they've already heard. No other court in Ghana can rehear a case that they've already been presented to them. And they also have the jurisdiction for the provision of official documents in court. That means that if there is a situation where there needs to be the provision of official documents, what is official documents? We are talking about state documents. Some state documents are very, very confidential and shouldn't come out. So if the evidence is based on a state document, they would have to go to the Supreme Court for the Supreme Court to decide whether bringing that document out is going to compromise the national security, or is going to cause chaos, or it is going to be appropriate to bring that document out. If the Supreme Court says that that document should not be brought out, then you would have to find a different evidence. So the Supreme Court has the jurisdiction for the production of official documents in court. If you want to produce an official document, that's a governmental document in court, they would have to see whether it is a confidential document. And even if it will be presented, should it be presented to the public, or should it be presented behind closed doors? Or should it even be presented on a camera? So the Supreme Court has a jurisdiction to do all of that. And if there is a case that your evidence is hinged, the official document may compromise the security of Ghana, the Supreme Court may decide not to release the official document. Watch this US movies, you realize that even sometimes, if certain portions of it, those of us who watch these US movies, sometimes in an official document, you realize that they will just redact certain portions that they deem as what very confidential, and they will release the rest to the public. So even they can even do that. Okay, so even if they are releasing the documents, they're going to redact certain portions that may compromise the security of the nation. And then lastly, they have supervisory jurisdiction. Now, supervisory jurisdiction is their jurisdiction where they can supervise all other courts in Ghana, in addition to all other arms of government and all other agencies. So the Supreme Court supervises all of these people. Now, in this supervision, they can issue certain writs or certain orders to make sure that the people conform with whatever they are doing. So, examples include certiorari, prohibito, mandamus, quo warranto, and habeas corpus. Now, with certiorari, it is a Latin word which means a quashing order. And the quashing order is a decision by the Supreme Court or an order by the Supreme Court to cancel a decision made by a court below it because the court didn't follow the appropriate procedures. It can be that the court has breached the rules of natural justice, or the court didn't follow the appropriate procedures, or even the court doesn't have the jurisdiction to hear that case. So if a court errs in a decision making, the Supreme Court can issue a certiorari, which is a certiorari, which is a quashing order, to cancel the decision made by the lower courts. So after the decision is made, if you believe that the decision was made in error, you can go to the Supreme Court for the Supreme Court to issue a certiorari, which is a quashing order, to cancel that decision. And also we have a prohibito. Now, prohibito, you don't wait till the decision is made. If you think that a court is hearing a case that they do not have the jurisdiction or the power to hear, you can go straight to the Supreme Court, and the court is going to issue a prohibito to prohibit them from doing whatever they are doing. That means that even before they come up with the wrong decision, the Supreme Court is going to prohibit them from even what carrying on, not to talk of what bringing out what a faulty or what an unjust or even a decision at the end. So certiorari is given after the court has given a decision. The Supreme Court will cancel the decision, and then the prohibito is given before the decision is made. So, for example, the High Court has a case presented to them, and then in executing the case, the High Court is interpreting the Constitution. If you find out, you can just go to the Supreme Court and alert them that the High Court is interpreting the Constitution and they do not have the jurisdiction to interpret the Constitution. And then the Supreme Court is going to issue a prohibito. Issue a prohibito to the High Court that they should what? Stop it and what? Bring the case to the Supreme Court. So that is what prohibito. Now we also have mandamus. Mandamus is a mandatory order. Now this mandamus usually applies to other governmental agencies, but it can also apply to the courts. Now this mandamus is such that it is to make sure that a government or agency does what they are supposed to do. So it is to mandate them to do what they are supposed to do under the law. So when we talk about this supervisory jurisdiction, they supervise all courts below them, plus other government organs and also other government institutions. So you see me use them interchangeably when I'm explaining. So with this mandamus, if there's a governmental agency and they are supposed to do something for you and they are not doing it, you can just sue them in the Supreme Court, and the Supreme Court is going to issue a mandamus to mandate them to do whatever they are supposed to do. For example, you are Ghanaian, you've done everything, and the Electoral Commission is refusing to give you your voter's ID. They are supposed to give you a voter's ID if you satisfy all circumstances or you satisfied everything, but they do not want to give it to you, maybe because of political affiliations or other things. So based on that, you can apply to the Supreme Court for the Supreme Court to grant you a mandamus for you to mandate them to what? Provide you with an EC. Now, this case, this example that I'm giving you is a real case that happened in Cape Coast North, where an aspirant wasn't given a voter's ID based on some technicalities. He went to the court, and then the court ordered a mandamus to the EC for the EC to what? Grant him the voter's ID. And then we have co-warranto. Co-warranto is just questioning your authority by which you did something. So co-warranto is simply translated by what authority. So if someone does something, or someone occupies a position, or someone is using his position to do something, and you believe that they are going beyond their authority, you can go to the Supreme Court, and the Supreme Court can issue a co-warranto to them for them to come and explain the authority by which they are doing whatever they are doing. Now, if you occupy any governmental authority agency, your powers either come from the Constitution or an act of Parliament. So if you are doing something that where your power cannot be traced from that sources, then it means that you do not have the authority to do whatever you are doing. So sometimes some people can act in certain ways, and then you would want to know by what authority that they are doing. So the Supreme Court can invite them and ask them that, okay, so they occupy this position, they took this decision, by what authority did they use? And if they are not able to justify, the Supreme Court can what? Undo the decision. Also, we have habeas corpus. Habeas corpus in English is produce the body. Now, all the words that you are seeing there are Latin words. In English, it means produce the body. Now, I always have to prompt students that the body that we are producing is not a dead person, but an alive person. So this one is usually issued to law enforcing agencies. Now, these law enforcing agencies in Ghana here, if you are being detained for more than 48 hours and they do not have any cause, they have to let you go. So if you are there and they don't let you go, then your representative can go to court for the court to issue a habeas corpus. They have to what? Produce you in court. They have to produce your body. That is what we mean by produce the body. So they have to produce you in court. So they either charge you with a crime or they let you go. Other than that, some people can just be arrested without any evidence and they will put in prison, and then no one will come for them. I think even some are still happening. So because of habeas corpus, the police cannot what? Keep you there for more than 48 hours. If after 48 hours they don't find evidence, they would have to produce you in court. And then they have to tell the court that this is what they found. And the court, based on that, is going to decide whether it is enough evidence for them to what? Keep you locked up or what? Release you. Sometimes, even if they've not found evidence and their crime is very serious, they can ask the court for an extension, or they can ask the court that they should give them more time to what? Find evidence. For example, in a murder case. However, after 48 hours, if they don't find anything on you, your representative can go to the court for the court to issue a habeas corpus. That is that they have to either produce you in court. When they produce you in court, they have to either charge you or what? Let you go. And the court is going to decide whether it is going to let you go on a bail, or it's going to what? Keep you in prison based on the evidence produced by the law enforcement agencies. Now, every supervisory jurisdiction that I've mentioned, the High Court has similar supervisory jurisdictions over lower courts and other agencies, but they cannot supervise everything. So the Supreme Court can supervise everything based on whatever I've mentioned, but the High Court has limited supervisory jurisdiction. That means that the High Court also has supervisory jurisdiction, but they cannot supervise everything that the Supreme Court is supervising. So I'm saying this because when we get to the High Court and I'm mentioning the supervisory jurisdiction, I'm not going to mention this again. So the electoral commission example that I gave, it went to the High Courts. It went to the High Courts can also issue a supervisory jurisdiction. Now, sometimes the High Court can do something and the Supreme Court can do something. That is known as a concurrent supervisory jurisdiction. And when that happens, we say that the Supreme Court is going to leave it for the High Court to what? Handle that concurrent supervisory jurisdiction. And then the Supreme Court is going to handle the ones where the High Court cannot handle. For example, when it comes to Parliament doing something in excess of what? An issue with Parliament, or an issue with what? The President, where you have to go to court and other things. Those ones are reserved for the Supreme Court. The High Court can supervise the courts below, that is the lower courts below, that's the Circuit Court, District Court, and then the the juvenile court, and it can also supervise other agencies and other authorities and what more authorities. However, when it comes to certain specialized supervisory jurisdiction, it is left for the Supreme Court. And a typical example is when it involves Parliament, the acts that they've passed, whether it is in contradiction with the Constitution, any constitutional issues with the president and everything, it goes straight to the Supreme Court. But the High Court can also handle other issues in relation to the supervisory jurisdiction. Mind you, even though the Court of Appeal is higher than the High Court, the Court of Appeal does not have any supervisory jurisdiction. Supervisory jurisdiction is only held by the Supreme Court and the High Court. So the Supreme Court supervises all courts below it. So the Supreme Court supervises the superior courts below it plus the lower courts, whilst the High Court supervises only the lower courts below it. When it comes to other agencies, especially if it relates to the Constitution, the supervisory is given strictly to the Supreme Court. But with other agencies also that are not strictly related to the Constitution and other things, the High Courts can handle the supervisory jurisdiction of that nature. I'm mentioning this, like I said, when I get to the High Courts and I get to the supervisory, do all of this. So everything that I've mentioned here, certiorari, prohibito, mandamus, quo warranto, habeas corpus, they can also be issued by the High Court. But depending on the case and depending on what the case is entailing, it will decide whether you send this. So it is going to decide whether this case is going to be supervised by the Supreme Court or must be sent to the High Court. Mind you, every supervisory case that the High Court can supervise, the Supreme Court can supervise. The Supreme Court is higher than the High Court. So everything that the High Court can supervise, the Supreme Court can supervise. However, the reverse is not true. What the Supreme Court can supervise, the High Court cannot supervise. So usually the Supreme Court leaves the ones that it can supervise to the High Court, and then the ones that the High Court cannot supervise, the Supreme Court takes it on exclusively. Next, we go to the Court of Appeal. Now, the Court of Appeal is made up of the Chief Justice and not less than 10 justices. For the Supreme Court, it was the Chief Justice and no less than 9. But when it comes to the Court of Appeal, it is the Chief Justice and no less than 10. And then we may have any other justices of the Superior Court as the Chief Justice may in determination, they can all form part of the Court of Appeal. Now, when they are working, they work in 3 justices. So they sit in 3 justices to hear appeals in the Court of Appeal. Now, to qualify to be a Court of Appeal justice, the high moral character and proven integrity, like I said, it is constant, and then you must have 12 years in good standing as a lawyer. Supreme Court was 15 years, Court of Appeal is what? 12 years. Now, jurisdiction. Now, their general jurisdiction or their main jurisdiction is appellate jurisdiction. Appellate jurisdiction, that is the main jurisdiction. They do not have original jurisdiction, they do not have any other jurisdiction apart from the appellate jurisdiction as the main one. They also have single justice jurisdiction, but that one is related to the appeals that they are hearing. So the main one is what? The appellate jurisdiction, where they hear appeals. Now they hear generally they hear appeals from the High Court and they hear civil cases from the Circuit Court. So if it's a civil case that is coming from the Circuit Court, it skips the High Court and it goes straight to the Court of Appeal. That is the appeals that they hear. And then with the single justice, they handle procedural or preliminary matters and not the main appeal or the main case itself. So their main jurisdiction is the appellate jurisdiction. However, they may have single justice jurisdiction where they want to determine certain things that would form part of an appeal. Remember, they sit in 3s. However, if there are certain preliminary or procedural matters, a justice can sit on it and the justice can what? Decide that, okay, so you want an injunction based on something, maybe you want to stay proceedings. All of these preliminary and procedural issues can be handled by one justice. But when it comes to the final decision of the appeal, one justice cannot do that. All the 3 justices must be seated and they must do that. That's why I mentioned that their main jurisdiction is what? The appellate jurisdiction. However, they may have a single justice jurisdiction where they are deciding on what? Preliminary or procedural issues. All right. Let's now go to the High Court. Now, the High Court is made up of the Chief Justice and not less than 20 justices of the High Court. So at any point in time, the justices of the High Court should not fall less than 20. Now, also such other justices of the Superior Court of Judicature, they can all sit in the High Court. So all of these people can also sit in the High Court. Now, when they are working, they work by a single justice. So a single justice can sit in the High Court. We can have a justice and a jury. We can have a justice and assessors, and then we can have what? 3 justices. Now, these 3 justices, when they sit, then it means that the issue is serious. The issue is serious because the issue they are trying for is what? High treason or what? Treason. And as I've already mentioned, high treason is when you want to abrogate the constitution itself. And treason is where you want to what? Overthrow the organs of the 3 main organs in Ghana. So this is a simplified view of it. You can read more on it, but high treason is mainly in relation to the what? Constitution. If you want to abrogate the constitution, then you commit high treason. We go to the Supreme Court because it's a serious issue. 3 justices must sit on it. But with any other issues, you can have 1 justice sitting on it, 1 justice and a jury, and 1 justice and an assessor. Now, the difference between a jury and an assessor is that the jury comes up with a decision at the end. So if you are prosecuted for a crime and then you are being indicted and then there's a jury, the jury will be of your own peers. Now, this jury, I don't know, in more advanced countries, they are being written and then, like, they write a letter for it to come for jury duty. But in Ghana here, I don't know whether any of you has gone for any jury duty before, but sometimes people are invited to come for jury duty. That is where they form part of the jury to decide whether somebody is guilty or not. In Ghana here, because of our system, I have not received any jury duty notice in Ghana, but that's how it should be. Now, with a jury, when you go, the justice is going to help you decide which of the evidence you should include, which of them you shouldn't include, and everything. And then at the end, the jury comes up with a decision. At the end, the jury comes up with a decision, whether you are guilty or whether you are not guilty. However, when it comes to assessors, assessors are people who are what? Experts that would help the justice come up with a decision. So the juries, they make the verdict, but when it comes to assessors, assessors don't make verdicts. So for example, it's a very specialized case that requires certain expertise from certain people. So then you can have what? Assessors helping you to what? Assess the case. So that's the difference between what? A jury and an assessor. But when they are sitting, they can sit as a single justice and a jury, a single justice and an assessors. And for what? Treason and high treason, they must be what? 3 justices. Now, divisions, so the divisions of the High Courts, they can have the fast track division, the commercial division, the land division, labor division, human rights division, financial and economic, and then we have the general jurisdiction division. So these are divisions that you can find in the High Court. Now, with the human rights division, as the name entails, you go there if there's a human rights issue. With the commercial division, you go there if your issue is commercial in nature, that's business related. Land division settles land disputes. Labor division, as you can hear, it's what? Employment issues and what? Those kind of stuff. Economic and what? Financial and economic crime division handles issue of what? Fraud and what? Cyber, all of this cyber security fraud and other things. You go to financial and economic crime divisions. And then we have other divisions under what? The general jurisdiction, where they handle other cases. Now, we have the jurisdiction of the High Court. Now, the High Court is usually known as the mother of all courts because almost every case can be sent to the High Court. So under the Constitution, the High Court has original jurisdiction over all matters. That means that they can hear everything, every type of crime, everything, except the one that has been what? exclusively marked out for Supreme Court. So unless something is exclusively marked up to the Supreme Court, everything can be heard by the High Court. It doesn't matter the weight of the crime, it doesn't matter anything. Everything can be sent to the High Court, except it has been marked exclusively that, okay, so as for this one, we should give it to the Supreme Court. Other than that, all matters can be sent to the High Court. All matters can be sent to the High Court. Also, they have the original jurisdiction over fundamental human rights issues. So if you have a human rights issue, personal human rights issue, you go to the High Court. You cannot go to any other court first. When you say original jurisdiction, you have to go to the High Court first before appeals can go to the other courts. So when it comes to original jurisdiction, they have original jurisdiction. Sorry. They have original jurisdiction over what? All issues except the one that are exclusive to the Supreme Court. And then they also have original jurisdiction over what? Fundamental human rights issues. Now, next, the appellate jurisdiction, they take appeals from the circuit court if it is criminal in nature, and they take appeals from the district court and the juvenile court of all natures. So these are the jurisdictions or appellates in nature from the High Court. Now, they also have supervisory jurisdiction, as I've already mentioned. They have the same, they can issue the same rates, but dependent on the case. So depending on the case, they're going to see whether the High Court can handle it or it has to be exclusively handled by the Supreme Court. But they issue similar orders and similar rates, as I've already mentioned and explained. We move to the Circuit Court. Now, the Circuit Court is being governed by Section 40, Subsection 4 of the Courts Act. Now, for you to qualify moral character, privilege, integrity, constant, you must have 5 years standing as a lawyer. 5 years standing as a lawyer. Now, they have original jurisdiction in civil issues that do not exceed 2 million Ghana cedis. 2 million Ghana cedis. That means that if you have a civil issue where the issue does not exceed 2 million Ghana cedis, you can go to the Circuit Court. You can go to the Circuit Court if the issue does not exceed 2 million Ghana cedis. If it exceeds 2 million, then you have to go to the High Court. But if it does not exceed 2 million Ghana cedis, you go to the Circuit Court. Now, in criminal matters, they can handle all criminals other than treason and offense triable by indictment or punishable by death. So basically, they can handle all criminal issues except what the ones that are punishable by death or treason and high treason. You remember treason and high treason, that one goes straight to the High Court. So serious crimes and crimes punishable by death, you'd have to skip them and go to the High Court. But petty thefts, petty robbery, all of those things, you can take it to the Circuit Court. However, if there is a murder, if there is an issue, an offense punishable by death, you cannot go to the Circuit Court. You'd have to go straight to the High Court. Also, if it is treason and high treason, you go straight to the High Court. We move further to the District Court. Now the District Court is also governed by the Court Acts, Act 494 as amended by 674. Now, the qualification of the District Court, you must have high moral character, proven integrity, and the years as a lawyer must be what? 3 years. At first, we had people known as the career magistrates, where the law allowed them that they could be magistrates. Now, I've been mentioning justices, judges, and magistrates interchangeably. Now, if you are manning the Superior Court of Judicature, you're known as a justice. It's a name that is given to you. So we have the Supreme Court Justice, Court of Appeal Justice, and the High Court Justice. If you are manning the Circuit Court, you're known as a judge, so the Circuit Court Judge. And then if you are manning the District Court, you are known as a magistrate, so the District Court Magistrate. These are just what names given to them because of where they are. So if you see me using justice, judge and magistrate, you should know where I'm using it to. Justice is for superior courts, judge is for judges for the circuit court, and then for district court we have magistrates. So for the magistrate, you need to have what 3 years in good standing. And as I was saying at first, if you could be a career magistrate where even if you're not a lawyer and you have legal knowledge in law, you could be appointed as a magistrate. But as the amendments came in, we need what people who have what 3 years standing as a what lawyer, at least 3 years for you to be appointed as a district court magistrate. High moral character, improved integrity, constant. Let's go to the jurisdictions of the district courts. In civil issues, they can handle issues where the amount is not more than 500,000 Ghana cedis. 500,000 Ghana cedis. That means that with any issues, it should not be what more than 5. If it is a contract issue, it's a land issue, it should not be more than 500,000 Ghana cedis. Now, for criminal issues, they cannot hear an offense that is punishable by a fine exceeding 500 penalty units or an imprisonment of what no less than 2 years. So if a crime can be punished and the punishment is more than 2 years, you can't go to the district court, you have to go to the circuit court. But if the crime, the maximum that it can be punished with is 2 years, they can go to the district court. And also, if the fine exceeds 500 penalty units, now each penalty unit is what an amount that is being costed. So if we calculate and it is more than 500 penalty units, then you cannot go to the district court. You have to go to the circuit court. And if it is a serious crime, such as murder or the punishment is death, then you have to move straight to the high court. So you see that the more serious the crime gets, the more you cannot go to the lower court. You have to now go to the high court. Now, based on this court structure, we now go to the juvenile court. Now, the juvenile court is usually doubled, so the district court usually doubles as a juvenile court. Usually, the Chief Justice is going to designate a district court as a juvenile court. Now, a juvenile court shall be composed of the magistrates as the presiding person and 2 other persons who are from social welfare. 1 person being an officer and another person being 25 years. The 2 of them shall be appointed by the Chief Justice. Now, a juvenile court has power to hear any matter, civil or criminal, that involves a person under the age of 18 years old, and shall for the purpose have the powers of the district court. So sometimes, if you're in a juvenile court, so if you're in a district court, and the person that is being tried or the person whose case is being heard is someone below the age of 18 years old, then we are saying that in that section is now viewed as a juvenile court. And in that juvenile court, you must have a magistrate and have 2 people, one of whom shall be social welfare, because here you are talking about a kid. So you must have someone from social welfare, and you must have another person appointed by the Chief Justice to help. Because sometimes the punishment given to adults shouldn't be the same punishment given to people who are minors. I'm watching this man of God's name. The man of God whose son hits what's the name? The man of God whose son hits the people and then 2 died. I think 2 or 3 died. Who remembers that man of God?
Duncan Williams.
No.
Salif Amwakun.
Salif Amwakun.
Yes, Salif. Yes. Yes. Yeah. Do you remember the punishment given to the kids?
I think they went for just 6 months or 3 months.
Yes. You see, did he kill 2 or 3 people? I think the accident killed how many people?
2.
Yes.
2 girls.
2 girls. Thank you very much. Now, if an adult had killed that person, that adult wouldn't have gotten 6 months. So if you are tried as an infant, the punishment given to you is less. But sometimes when they look at the crime and they look at how intentional you are, Sometimes even a kid can be tried as an adult. So kids must be very careful. But sometimes you would think that all kids will be tried as what? Kids. Sometimes even if you're a kid, for example, you're 16 years old and then you brutally rape someone and then what? You cut the person. Those ones, sometimes you can be tried as an adult. That was something can be put, you can be put in a correctional facility, and then when you're 18 years old, they try you as an adult. But generally, we are saying that if you are dealing with what infants, those infants, we try them in the juvenile court. In the juvenile court, the punishment is not as serious as the main court or what an adult court. Now, in Ghana here, if you are below the age of 12 years, you cannot commit a crime. If you are below the age of 12 years, you cannot commit a crime. That means that if you stand there and let's say someone who's 5 years old stabs you, that person can go scot-free because it is assumed that the person doesn't know what they are doing. It's assumed that the person doesn't know what they are doing. So in Ghana here, if you are less than 12 years old, you cannot commit a crime. So it means that it is dependent on the adult to make sure that he is not harmed by the child. Even people who are adults and who are insane, if you stand there and you are hurt by someone who is insane, a mad person, you cannot take that person to court. So if you stand there and you are being hurt by a mad person, you cannot send that person to court. Same way, someone who's less than 12 years. Now, the idea is that they do not know what they are doing. That is the idea. So if you see a kid holding a knife, you take the knife from the kid. So the idea is that they don't know what they are doing. Because if we start arresting children and then we start persecuting children, that means that if a child who is like 5 years old, let's say, stabs someone and unfortunately the person dies, then that child will be put in prison. But the idea is that they do not know what they are doing. So in Ghana here, we have the juvenile court handling issues that involves children. Juvenile court handling issues that involves. So now, that one is known as what? Doli incapaz. That is incapability of crime. So if you are less than 12 years, it is assumed that you are incapable of crime. And as our laws are legal, are whatever influenced by Latin, the Latin word is what? Doli incapaz. That means that you are incapable of committing a crime. Now, so this is what kind of, how should I put it? I don't want to say a warning, but a precaution that if a kid is wielding something dangerous, it is up to you to make sure that what you take it from the kid, because if all is said and done, when you go to court, the kid will be what? Seen as someone who cannot commit a crime. Now let's go to challenges of litigation. Now all we've gone through are what? Litigation. The court system, we go to court, what the court can handle and other things. They're all known as what? Litigation. Now, this challenge of litigation is the reason why they ask us to adopt ADR, the Alternative Dispute Resolution. So, challenge of litigation, one, we have cost, and so we have delay. There are some cases that have been in court over 12 years, over 20 years. Lawyers have died, judges have died, and the cases are still persistent. It can be a land dispute. Because we don't have enough evidence, we cannot what? Prosecute. Because we don't have evidence, we cannot what? Prosecute. So because of that, it is what? A challenge to litigation. Next, we have cost. Now, it's not that ADR doesn't have any cost, but sometimes the cost of hiring a lawyer, going to court, paying legal dues, paying legal fees, paying court fees, by the time you realize it has what? Costs you very much. So we say litigation is what? Very expensive. And litigation is it's in such a way that it can destroy a relationship. Even in our villages, sometimes you go to your village and then one house doesn't speak to the other house just because their great-grandfather sued the other person's great-grandfather. So they are not speaking terms. Now, because litigation produces a win-lose situation, hardly would you see two people battle out in court and then the decision will favor one person, and then after that, they will. Also, sometimes there can be lack of expertise. Sometimes the judge is only experienced in the law. They may not be experienced in other aspects of life. So they may be normally experienced, but the critical expertise in certain aspects of life, they may not be able to handle it. So, for example, if you have a marital issue, you can go to the marriage counselor, you can go to therapist to help you solve your issues. However, when you go to court, the judge may just have legal idea of what a marriage is and how to handle legal issues in marriages. He may not the judge may not have the expertise when it comes to marriages, and it can come across a lot of areas. Now when you go to court, they will just apply them. Yeah, Juliana.
So please, your network it's not stable.
It's
There's
breaking.
scratches on it. Yeah.
Wow. I'm connected. Let me see if I can switch my network. In Ghana here, networks are not even. Use MTN, it doesn't work. Does anyone work with MTN here, or we are all teachers? This is what I'm coming. Is it better now?
Yes, please.
All right. So, lack of expertise. Sometimes the judge may lack certain technical expertise when it comes to certain areas. Even though they may know the laws surrounding a particular area, they may not have a technical expertise, and this may lead to ineffective remedies given by the courts. So these are the challenges of litigation. These are the challenges of litigation, and because of that, we are being advised to now use alternative dispute resolution. Alternative dispute resolution. Now, ADR is a procedure for settling disputes without using litigation. When I say litigation, I mean that without going to court. Without litigation means that without going to court. Now, it provides a flexible and a less formal method for dispute settlement. So examples include negotiation, mediation, conciliation, arbitration. You can have mini trials, settlement conference. You can have a combination of mediation and arbitration. Also, you can rent a judge to help you solve your disputes. However, the most common ones that we use normally in Ghana includes the negotiation, mediation, and then arbitration. So that is what we'll be discussing mainly here. If you have time, you can read on all of these times, but we'll be focusing more on negotiation, mediation, and conciliation. All right, so let's pick mediation. So let's start with negotiation. Now, negotiation is such that is I hope you can still hear me clearly.
Yes, sir. Yes, we can hear you.
Now, this is where only two people, the two parties, will sit down and decide that we're going to solve the issues themselves. So, negotiation, the two parties will sit down and say that they're going to resolve the issues themselves. Here, there is no third party helping them. Here, the two people. So, we are like to give this non-conventional example. If you have a marriage, then there is a dispute, and the husband and wife decide to settle themselves. That is the example of negotiation. Here, they are settling the issue without the use of any third party. So here, maybe at midnight, they can get up and then can decide that okay, so they are going to resolve the issues. I heard that is the time that's people are upset. So when that happens, that is when that's what happens. In businesses also, business can decide not to go to us. Can decide not to employ the
can decide that they themselves are going to sit down. Sometimes they may have representatives there, but it's still between the two parties, it's still between the two businesses. So here they are discussing ways in order to make sure that they reach a settlement. So that is what negotiation. Only the two parties are there resolving the issues themselves. Now let's we go to mediation. Mediation, there is a third party. But the third party is helping them come up with a decision. The third party doesn't pose a decision. The third party is helping them come up with a decision. So when it comes to this mediation, here the third party will listen to both parties and help us suggest ways by which they can resolve their issues. It is not compulsory that we have to listen to the third party. Now let's also start from the non-commercial example. For example, if you have a marriage settlement to help with an issue, you can decide to go and see the elders from that's the opinion to help you to resolve the issue. And those of us who are very religious, we can tend to go to our pastors or our pastors are filling certain courses in this counseling. So we can go to pastors for marriage counseling. So these pastors are going to help us resolve our disputes. Now the pastors cannot force you to stay in marriage. For example, somebody has done something bad. The pastor cannot force you to stay in marriage. The pastor can quote scriptures and the pastor can discourage you. Divorce is not a good thing. Divorce may affect them. See a lot of things. And at the end, you can tell the pastor that is too. That's how the issue is. So mediation here, the third party is there to help you come up with a decision. So when you listen to the mediator, you forgive the person that you want to stay. But if you don't want to stay in the marriage, you decide not to stay. Yeah, the decision is solely based on the parties. That is what mediation. There's a third party helping the parties come up with a decision, but the third party cannot help the decision. And then next we go to arbitration. Now, arbitration is like a mini trial, it's like a sports, but without a formal English. Now, when it comes to arbitration, we are saying that there's a third party. However, the third party makes a decision for the parties. So, even though it's an ABL process, the third party makes a decision for the parties. That is what arbitration is. Arbitration is like an informal court section where you will provide everything to them, and then after that, the arbitrators will make a decision, and then the decision is binding on you. Now, after the arbitrators make a decision, you have to send it to the High Court for the High Court to grant leave of that particular decision. And then if the High Court grants leave of the decision, it will be as if the High Court itself came up with that decision. So if you are going for arbitration, make sure that you understand that for arbitration, the arbitrators are going to make a decision that is binding. You can choose not to go for arbitration. You can choose to make sure that, okay, so if this is the arbitration. But if you go and you decide the parameters of the arbitration and everything is set, and arbitrators come up with a decision, then that decision is binding. That is how this APR mechanism, that is how this arbitration goes. Now, once the decision is binding, the arbitration gives way for to challenge the award. So you can challenge, first of all, that person is telling you that the decision made by arbitrators, so these decisions made by arbitrators can be challenged. For example, yes, sorry.
Please, there's a lot of noise at the background.
Yes, sorry about this. I hope it is okay.
It's better.
Thank you. So with arbitration, I'm saying that you can challenge the circumstances surrounding our work. So, for example, if you feel like the arbitrators are biased, they didn't follow certain procedures, or if they have an interest in it, in law, you cannot have, cannot be the judge of your own kingdom. You cannot be in a case where you have your interest in it. So based on that, you cannot have that. So you cannot have an interest in the kingdom you are not. So if they are treated, you see all of these particular issues, they can challenge their award in the records. However, on the outset of this changes, then we are saying that arbitration agreements. Now with ADR, generally, if the parties decide, it is sometimes difficult to enforce it. I don't have a kind of ADR, but with the arbitration, the arbitration there is binding on you to send to the High Court or the so as for the arbitration is binding. Now with other forms of ADR, sometimes you want to enforce it. So if the parties agree on it and they plan to decide, in law you are bound by the signature. As for that one, you will have to go comply with it. Sometimes if you just make an agreement and it will become difficult to enforce that particular agreement. And we are saying that when they give pen to paper and they sign, so a disadvantage of ADR will know what's here by the disadvantage of ADR can be that it's force a particular agreement. However, if they put pen to paper, they sign and they write an agreement and they sign, and it's that the other words easier to enforce. So that is what ADR. So these are the main discussed. The first one, conversation with counsel elements. The second one, mediation is a third party, and the third party is going to impose a decision. And last one, arbitration, the third one comes up with a decision of the binding of the parties. And one that I have to do is what did I have to do is that the parties have to send to the High Court for the High Court to grant leave which they enforce. And if you think that there is any issue with the surroundings and any plan to decision, you cannot challenge the award. So these are the mechanisms of ADR. Let's look at a few advantages and disadvantages of ADR. Now, ADR is less costly. Even though it will cost you some money, when it comes to ADR, ADR is less costly than litigation, especially if you choose to use the negotiation approach. With the negotiation, it is just you and the parties negotiating. So when you compare the ADR and then you compare litigation, ADR is less expensive than litigation. It is also simple, and then it does not also take a lot of time. ADR doesn't cost a lot of time. Now, it is partly owned by the parties because, especially when it comes to the other part of it, like the negotiation and then the mediation, the parties actually own the process. The parties actually own the process. Even in arbitration, sometimes the parties can decide the laws that should be applicable and the scope in which the arbitration should cover. So even with arbitration, the parties still own the process. Now, it produces a win-win situation. Generally, produce a win-win situation. We have discussed it. For example, we are fighting over a land. The land is about 10 acres. Instead of going to court and fighting and spending money and everything, why don't we just split the land into two? You take 5, I take 5. Everybody wins. Then we go into court and then there's a win-lose situation. One person gets 10, the other person gets 10. So ADR can produce a win-win situation. Also, it is private and confidential. In ADR process, not everyone can go and sit in the proceedings. In ADR process, not anyone can go and sit in the proceedings. For example, in a marriage counseling, this is when I'm coming.
All right, sorry about that. So, like I was saying, ADR is private and confidential. Let's pick a marriage counselor. When you go to a marriage counselor, it is just you, your spouse, and the counselor. Anything you say there is confidential. They must not even tell anybody about whatever you've told them. But in a court system, generally, people can just come and sit in your case. So even if you are airing your dirty laundry outside, everybody is going to be aware of your dirty laundry. When you go to court, today, you can just get up and walk and then go and sit in the court and listen to anybody's case. That's a general view, unless probably it's a rape case that they are trying to protect the victim, or it's a serious crime that they are trying to cover and make sure that people are protected. But generally speaking, most court cases, you can just walk and then just go and sit in any court proceedings. I just walk and go and sit in any court proceedings. So that limits the privacy and confidentiality of the court proceedings. But with ADR, it is private and confidential. The person listening must not tell anybody. And even in the process, you are the only two parties there, and there's no other person there. Unless it is what involving a third party. And even with a third party, not everyone can just walk and come and sit in your case. Also, it promotes good business relationship. If there's a win-win situation, you like to do business because you realize that the person can what? You can negotiate with the person. Nobody likes to do business with a litigant. Not someone who's with every small thing, they just see you in court. Anytime that they are bringing business, you do not even want to do business with them because you know that this person is a litigant. So ADR, when you resolve your issues amicably, it helps promote good relationships. Now, demerits. There is no right of appeal, with the exception of, let's say, the arbitration where you can just challenge the award. Generally, with ADR, there is no right of appeal because usually you make the decision yourself. You came up with your own decision. So what are you going to appeal? If it's a negotiation, you came up with a decision, you said what you wanted, the other person said what they wanted, and then you agreed on it. So there would be no right of appeal because if you are appealing your own decision that you've made, and you cannot do that. Also, there's fewer absence of evidentiary or procedural protection. When there's evidence or procedural protection, there's nothing like that because there's no procedure. They can start from anywhere and end at anywhere. Also, with evidence, sometimes when it comes to evidence protection, they can protect it in court, but when it comes to ADR, they cannot protect the evidence. So there's fewer or there's absence of what evidentiary or procedural protection. Also, parties can walk away at any time. With this one, if you are in a negotiation and it is not going well, you can just get up and walk away. But in court, you dare not. In court, you'll be held in contempt. Contempt is you disrespecting the court. Even the court, if you use certain languages that the judge deems as disrespectful, you can be held in contempt. But with ADR, the parties can just walk away if they feel like the process is not going their way. So that is a disadvantage of ADR, where the parties can just get up and walk away, just like that. And that can also lead to a delay. Now, sometimes also there's the ability of the strong party to bully the weaker party, especially in negotiation. With that same marriage example, if a man has cheated and the man is the breadwinner of the family, definitely if they are negotiating or they are resolving the dispute, definitely there are certain things that the man is going to see that the wife is going to keep quiet just because the man is more powerful and the man is the breadwinner of the family. So sometimes even in ADR process, when you can just resolve your dispute by yourself, there's the ability of the weaker party being bullied by the stronger party. Because you know that if you say no, there's nothing else you can do, or if you say no, it is going to be very disadvantageous to you. So because of that, you're just going to agree with whatever the superior party says. Now, even though there's a non-commercial example, we can move it to a more commercial example where you can have big companies bullying other people. Sometimes there are news that certain companies are emitting certain things into the rivers that people are drinking, and then it has caused them some sickness. Now, because of that, if you decide to sue the company can drain you of all the money that you have. So sometimes they can give you a settlement and tell that you either take the settlement and try and use the settlement to cure yourself, or you can chase them in court and you never get justice. So because of that, there are some powerful parties who can bully the weaker parties into accepting whatever they want. Also, you cannot measure objectiveness of the process. The process, there is no objectiveness. It is just a process where the parties can decide whatever they want generally. So you cannot usually measure whether everything went right or something didn't go right. Also, there is no development of precedents. Precedents is where you can use similar principles for similar cases. That is, if there's case A yesterday and today there's case B and case A is similar to case B, you can use similar precedents for case A for case B. That is the same principles for case B. However, with ADR, there's nothing like that. If today a man cheated on the wife and the man just bought a car for the wife to forgive him in, let's say, a negotiation settlement. Tomorrow, if a man cheats on the wife, they're not going to apply the same thing to the next one. So with ADR, there is no opportunity for development of precedents. That means that what happened in a previous similar case cannot apply towards the next case. Maybe the next person will just forgive the man based on what? Just an apology. So with ADR, there is no opportunity for development of precedents. Now, we have cases where ADR is not cannot be used. Cases where ADR cannot be used. Now, we have constitutional issues. As for those ones, ADR cannot be used. Constitutional issues. We also have human rights disputes. Those ones, ADR cannot be used. We have novel cases, that is, new cases that require precedent. So if there's a new legal case that requires precedent, you cannot use ADR to resolve it. Now, we also have serious criminal offense such as fraud, forgery, rape, where the party are seeking relief that can be obtained only from the courts. So if there is a serious criminal, even murder, with these serious criminal issues, you cannot use ADR to resolve them. You have to go through court for the court to punish the other parties. Also, we have environmental issues. If you are caught doing galamsey, is there any galamsey here? Put up your hand and let's see the people destroying our waters. Is there any galamsey here? Okay, so do you know of any galamseyers? Let me put it this way. You are not a galamseyer, but do you know any galamseyers? So nobody knows a galamseyer. This whole class, about 20 people, nobody knows a galamseyer. All right. So whether you are one or whether you know one, let them know that if they are caught, they would be prosecuted. You cannot use ADR to resolve issues of environmental nature. If the issue is polluting the environment or destroying the environment, then you have to be prosecuted. In Ghana here, if everything goes right and we're able to curb galamsey, you would see that all of these people will either have a prison time or would have a fine that is very, very heavy. So let's hope we get there so that they don't destroy all our other bodies. Now, next, we have something known as the court-connected ADR. Some ADRs are connected to the court. Now, they do this because they want to unjam the court system, or they want to show us that there are other avenues that we can use to resolve our issues and not always coming to court. So we have even certain acts and certain laws even encouraging us to use ADR before we come to court. If the ADR is not successful, then we can come to court. So criminal, commercial and court-connected ADR and next mediation are parts of the reform programs of the Ghana Judicial Service. Pursuant to the High Court Civil Procedures, mediation is practiced in the commercial division of the High Court as a mandatory pre-trial settlement procedure. So if you go to the commercial division of the High Court, they will first let you go through mandatory mediation. If it is not successful, then you can just move on to the litigation. but they will first let you go through what mandatory by force pre-trial settlement. Go through mediation, see if you can resolve it through mediation before you come to court, because the court has other issues that we can use ADR. So that means that if there's a case that we can use ADR, let's push them to ADR and then we should focus on other cases. However, if they are not able to resolve it, that means that it is serious that they would have to now what come to the court. That is how the court is working. Now, also the court encourages the use of ADR before coming to court. So they are what encouraging that because of the advantages of ADR, we should use ADR. However, if we are not able to resolve our dispute, then we can now what come to the court. Now, based on the above, the Ghana Judicial Service has introduced a program as for spending in court. So, and then you come back to the court. But if you're able to solve it through the court-connected mediation, the times that what case closed, everybody's happy, everybody goes home scot-free. All right, so this is the end of what we will do today. This is the end of what we will do today. So, any questions before we wrap up? Hello, any questions before we wrap up?
Hello.
Yeah, Elali.
Please, can you share the slides on our pages for us?
No problem. I'll share it with you. I'm encouraging everyone to join the business law page because I'll be sharing it. I'll be sharing this. I'll be sharing the Constitution and I'll be sharing the Court Act. I'll be sharing this, the Constitution and the Court Act, so that if you see any of the sections like section 2, section 72 and 73 that I've mentioned here, you can refer to the Court Act and then go and read on it and get more understanding of it. Now, every principle that I mentioned in this business law class is either coming from the Constitution, subsequent legislature, or an act of parliament, or a principle of the common law. So every principle that I'm mentioning, it is one coming from the Constitution, two coming from an act that we have in Ghana, or three coming from a common law principle that we have there from the British. So every principle, even if I don't mention some of these explanations, but the core principles are usually what found in each of the acts and the common law principles. But the common law principles are based on cases. Yeah,
Hello,
Juliana.
sir. Your
Juliana.
network is, sir, your network is not stable. So I can't
At all,
hear. I don't know if
okay, so let's
Maybe it's
decide.
your end.
Is it me or is
I can
Juliana?
hear him.
Juliana, then it is you.
Maybe your end. My side is okay.
Oh, okay.
Okay, so the good news is if my side is okay, then this call is being recorded. And because this call is being recorded, it will be shared to you. So if my side is okay, then it means that if you listen to the recording, you can hear everything. So that's how it's going to be. So that's the good news, that if it's my side, then you can just replay the recordings and then you can hear it. All right. So as I was mentioning, with the principles that I'm mentioning, they are coming from either the Constitution, acts, or it is coming from the common law based on a case. Now, this whole section was based on the acts and the Constitution. That's why they didn't see me mention the case. But subsequently, if we are doing contracts, we are doing any other course, you see that I'm going to mention cases. Give you just a summary of the cases. And these cases are very important. Now, when I mention the case, sometimes there may be some principles that may not be applicable to Ghana anymore. I'm going to tell you that, okay, so this is not applicable to Ghana, but this is applicable to Ghana. And based on that, we are going to move. All right. So if there are no questions, we would close. Our time is up. We'll close. Yes, and I wanted to ask. I asked and he said we are going to meet only 4 times. We are meeting only 4 times. That's what I'm hearing. According to the timetable, we
Yes.
are meeting only 4 times.
Yes, sir.
All right. Is it continuous or there will be a break?
It's continuous.
So we are meeting for 4 weeks. So we are meeting the next 3 weeks straight. All right.
Yes, yes, yes.
And is there a 5th week for tutorials?
Yes.
So we are meeting 4, and there's a 5th week for tutorials.
Yes, and examination, the
that's-
6th one.
When I write in the quiz, will we write the quiz after the 5th week?
The 5th week will be given, I think, a revision.
Yeah, the 5th week is
It's
revision.
revision.
So mostly, yeah. Then the
And then the
revision, then we'll
6th
write
one,
after.
So
then
you
followed
write
by
your
the
quiz during your revision.
after
So
the
you
No,
write your
the
revision.
quiz
quiz
during
is
the
after
revision.
the 5th week. The quiz is after the 5th week. So the 6th
So the
week is
quiz
the
after the
quiz.
5th week.
Yes.
Okay. So the revision, you like to revise on your own. You don't like to revise.
Sometimes it depends on the lecturer. If you are not done.
All right. So depending on where we get to, we'll try and then summarize everything so that we'll finish early. Okay. So I'll be sharing this. Like I said, if you've not joined the page, kindly join so that you get it documented. If there's any other subsequent information, you would get it. So if there are no questions, we'll end the God willing next week, same time we're going to meet.
So, please, can you give
Yeah.
us please, can you send us, if you have the software for the Constitution of Ghana, so that we can go through?
I'll send today. We've done the legal system in Ghana. So I'll send you today's slides, and then I'll send you the constitution and then the court acts.
Okay.
Mercy, you understand? If you have a question on mute, say speak.
Please,
Mercy, is it a
good
mistake?
morning.
All right. Yeah, good morning.
Hello. Okay, if there is any book that we can read online, please, I want you to give us.
See, when it comes to law, hardly will you get books online. Laws are not like accounting. With accounting, because of the adopted IFRS and principles and the framework, an accounting book in the UK works the same as an accounting book in Ghana. However, when it comes to law, it's only within the scope of Ghana. We have, even though we adopted a common laws, there are certain laws that we apply in Ghana that are different from UK, that are different from the US. So if you get artists, it may not be the same. So usually you would buy a book, and then based on the book, usually business law books are bigger. So you will see insurance, you would see other ones that you're not learning. So usually you buy a book and then you decide that, okay, so based on the book that you bought, you're just going to select the topics that we are doing. But business law books are very expensive. They are very expensive. Not even business law books are very expensive. So I don't know. I wouldn't advise online books because certain principles may not be the same. Certain principles may not be the same, but you can read to get a general idea. But if you want that, then I would have to contact colleagues in the law department and get you books, but it will be very expensive. As for business law, it's very expensive. So it will be dependent on the course. whether they want it or they don't want it. But business law books are very expensive.
Okay.
So I'll do my best to send you the slides and send you the corresponding acts. I'm hoping you'll be able to finish earlier. Then I'll take you through certain tutorials so that you get to understand a lot of things properly. So that at least you should be able to, understand things. But if you are still insistent on the books, hard copy, soft copies will be difficult. Hard copies are also expensive. So if you still want to buy a hard copy, then I would arrange with someone in the raw spring and I'll get you books. But like I said, the books they are very expensive. Maybe 60 cedis, around about 70 cedis for a business law book.
Okay,
All right.
sir.
So
Please,
if
I
there,
thought maybe. Hello, sir.
yeah, please, I'm listening.
I thought you may compile. You may compile
Yeah. So what I've
for us.
compiled is this. Yeah. So like I said, I'll send the slides to you. Everything that we are doing is in the
Okay.
slides. I'll send the slides to you. Don't worry. All right.
Okay. Thank you.
Okay. So you're welcome. So without any further questions, we would end here. Call in next week. We'll meet.
Thank you, sir.
Thank you, sir.